ಕೊಟ್ಟಲ್ ಕೊಟ್ಟಲ್ ಹೇಳಿ
ಮೆಮೋಸ್ ಬಂದ್ಮೇಲೆ ಇಸ್ಕೊಂತೀರಾ ಸರ್?
ಪ್ರಾಕ್ಸಿ ಹಾಕಿದ್ದೀರಾ?
ಮೆಮೋಸ್ ಅಡ್ಮಿಷನ್ ವರ್ಡ್ ಮ್ಯಾಟರ್ LB BB
ತಗೊಳ್ಳೋದಿಲ್ಲ
ಸರ್ ಲೈವ್ ಅಲ್ಲಿ ಇದೆ.
For being spoken. And then
My lord is not audible.
ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
Now it is audible.
ಹಾ?
Yes, it is now. It is audible.
Yes. Yes. I don't adjourn the matter, sir, unless the other side is here and says no objection. Huh?
My lord, serial number 1, my lord, for being spoken to.
42. Others are also there. B or Srivastava is there. No, sir. Yes.
Sir, serial number 49.
There is no difficulty, sir. When the matter reaches, we'll adjourn. Otherwise, if the advocate is here, I'll adjourn the matter. Yes.
Sir, serial number 49. ರೀಚ್ ಆಗೋ ಟೈಮಲ್ಲಿ ಅವ್ರು ಒಂದು ಟೈಮ್ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ. ವರ್ಷಗಟ್ಟಲೆಯಿಂದ ಜನ ಆಗ್ತಾ ಇದೆ ಮೈಲಾ. ಪ್ಲೀಸ್.
ಇವಾಗ ನೋಡ್ತಾ ಇದ್ದೀರಲ್ಲ ನಾನು ಹೇಳ್ದೆ ಅಂತ. Yes.
Serial number 24. Matter is getting settlement outside.
Same thing will apply to you also. I
Lords,
don't
I appear for the petitioner in this matter, my lord. Serial number 24.
24. You are for the petitioner.
Please, my lords, I appear for the petitioner.
You have no objection.
No, my lords. Settlement talk is ongoing, my lords.
Serial number 24. At the request of learned counsel for response number 1 to 3. Huh?
1 to 3 minutes.
Release this matter on 11th of June.
Grateful.
Yes.
For being spoken to, serial number 1.
Yes, Mr. Yatnal.
My lord, my lord, why disposing this HRP cases pertaining
Yes.
to assessment of the cost of the tree?
Ah,
The Honorable Court has made 2 categorization. One
yes.
is those cases which the already cost of the tree is paid, and another where it has to be calculated.
ಕಡಿಮೆ ಮಾಡ್ರಿ. Sound ಕಡಿಮೆ ಮಾಡ್ರಿ. Yes.
My lord, in these 3 cases, serial number 1, 2, 3, several judgment was dictated in the open court that the cost of the tree in these cases is already paid. So matter was accordingly disposed of. However, while
Oh,
typing it, judgment that regular order is also placed in this case. Therefore, in view of the payment of the cost of the tree, these 3 matters needs to be considered, my lord. In serial number 1, my lord, at annexure 4 and 5, 2 documents shows that the cost of the tree is already paid.
ಯಾವ್ದ್ರಿ ಅದು? Which is that other judgment, which is the type that you want?
But in that one more judgment case filed by Sri M.J. Alva, that original judgment was done and that was followed. But unfortunately, in that case also, the same judgment is the order is forthcoming, madam.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯನ್ರಿ ಅದು 2 ಟೈಪ್? ಬೇರೆ ಇನ್ನೊಂದು ಟೈಪ್?
ಇಲ್ಲ, ಇನ್ನೊಂದಿಲ್ಲ.
In all these matters, is it?
ಇಲ್ಲ, ಇದರಲ್ಲಿ serial number 4 is a
So,
different.
Yatnal, in all these matters,
1,
same
1, 2, 3, my lord.
1, 2 and 3.
Yes.
Purple. Matters listed for being spoken to. Learned counsel for the petitioner submits that this is a case where the competent authority has fixed the value of the trees. And therefore, the orders that were to be passed in this petition is in a different format. Please stop. Next para. Do you have the writ petition number?
That writ petition I don't have, my lord.
You don't have.
ಆ ಟೂ ಅಲ್ಲಿ ಕೀಮತ್ ಕಟ್ಟಿರೋದಕ್ಕೆ ಯಾವ್ದು ರಿಸಿಪ್ಟ್ ಇಲ್ಲ. ಸೀರಿಯಲ್ ರಿಟ್ ಪಟಿಷನ್ WP10983
ಹಾ.
ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಅವ್ರು ಹೇಳೋ ತರ ಇದಕ್ಕೆ ಮಾಲ್ಕಿ ಕಟ್ಟಿರೋ ಪೇಮೆಂಟ್ ರಿಸಿಪ್ಟ್ ಯಾವ್ದು ಇಲ್ಲ ಇದು. ಬರೀ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇದೆ 536 rupees ಏನೋ ಕಟ್ಟಿದ್ದಾರೆ ಅದರದ್ದು. whereas what he says all three matters are same ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
In third matter, my lord, I have filed along with a memo that is forthcoming.
ಆಮೇಲೆ
It is not
second one?
produced along with writ petition. I have produced along with
What about the second one?
second one. It is there, my lord. In second,
Hmm.
at page number 61, my lord, I have produced the bank DDR.
So the value
At
is
page
fixed and it is paid also.
Paid. It was paid through a DD dated
Value of the trees-
3/2012 at annexure C3, my lord.
One ನಿಮಿಷ. Value of the trees are fixed and the value is paid by the petitioner.
At page number 61.
Next para. Accepting the submission of the learned counsel for petitioner. The order dated 26/3/2024 is recalled and a fresh order is passed today. Having regard to the other writ petitions where similar set of facts, orders have already been passed by this court. Yes. ನೋಡ್ಕೊಂಡು ಕರೆಕ್ಟ್ ಮಾಡಿ ಇನ್ನೊಂದು ಡ್ರಾಫ್ಟ್. Yes.
Serial number 2, PG Etnad.
Serial number 2, 3.
1, 2 and 3 same. 4 and 5.
4 is with regard to
Village name has been wrongly mentioned. That is page number 2 in the
ಏನೋ
para 2 of the judgment, but village name has been wrongly. Gottigere village ಅಂತ ಬಂದಿದೆ, ಅದು ಬಸವನಪುರ ಆಗ್ಬೇಕು, ಬಸವನಪುರ. Page number 2, para 2 of the last line man.
ಹಾ.
So 38 Gunta situated Gottigere village ಅಂತಿದೆ ಸ್ವಾಮಿ, ಅದು
ಹಾ.
ಬಸವನಪುರ ಅಂತ ಆಗ್ಬೇಕು.
ಬಸವನಪುರ ವಿಲೇಜ್.
Please, ಬಸವನಪುರ village.
ಬರ್ಕೊಳ್ಳಿ. Matter is listed for being spoken to, comma, at the request of the learned counsel for petitioner. Full stop. Learned counsel for the petitioner points out from para 2 of the order dated 5th of April 2024 that the name of the village is wrongly mentioned as Gottigere
Please,
instead of
ಬಸವನಪುರ.
Basavanapura.
Please.
Full stop. Next para. ನೋಡಿದ್ರೇನ್ರಿ?
ಹೌದು ಬಸವನಪುರ.
The submission of the learned counsel for petitioner is accepted. Full stop. Office is directed to correct the name of the village in para 2 as Basavanapura village, comma, Beguru Hobli, Bengaluru South Taluk,
Please.
and issue a fresh certificate copy.
Please.
Serial number 5, PG Etnad.
My lord, in serial number 5, my lord, we have committed a mistake in memorandum of the writ petition. Therefore, I have filed two application for amendment of the memorandum itself and for correction of the judgment, I have filed in the counter. It seems those IAs are not placed in the file. I have filed two
Learned,
applications.
Learned counsel for the petitioner submits that although this matter was disposed of by order dated 25/4/2024, it was found that there are some typographical errors in the memorandum of writ petition itself. So consequently, the petitioner has filed certain applications seeking rectification of the mistakes in the memorandum of writ petition and subsequently necessary changes to be done in the order, final order of this court. Full stop. Next para. Release this matter on 30th of May 2024. Full stop. Office is directed to put up the IAs said to have been filed by the petitioner.
Much.
Fresh matter, serial number 6, Jagdish DC. Serial number 6, Jagdish DC.
Learned AGA takes notice for response number 1 and 2. Issue notice to respond number 3. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA.
Serial number 7, Gautama V.
For the petitioner, my lords, I have given the representation to the PDO to mutate the name of the petitioner, my lords, param number 9 and 11, and to issue e-Kata as per the court decree. Court decree, my lords, is in annexure A, page 11. And representation, my lords, is in annexure B, page 22.
Mangalore City Corporation.
Gram Panchayat.
Huh?
Sorry, my lords, I didn't-
ಇದು ಯಾವ್ದ್ರಿ 13204 ಕೊಡ್ರಿ.
Annexure A, my lords, is court decree, page 11.
ನೀವು ಅವಾಗಲೇ ಕೊಟ್ಟಿದ್ದ ಫೈಲ್ ಫಸ್ಟ್ ಒನ್ 13193 of 2024 ಕರೆಕ್ಟಾ? Serial number 6. Serial number 6 13193 ಕರೆಕ್ಟ್ ಆಗಿರೋದು ಕೊಟ್ಟಿದ್ದೀರಾ ಯಾವ್ದು ಬೇರೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಯಾವ್ದ್ರಿ ಫೈಲು? ನಾನು ನೋಟಿಸ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ನಲ್ಲ. ಇದಲ್ಲ ಅದೆಲ್ಲಿ ಮತ್ತೆ 13193 ಸೀರಿಯಲ್ ನಂಬರ್ 6. ಈಗ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಫೈಲ್ ಇಲ್ವಾ? ತೆಗ್ದಾಕೊಂಡು. Yes.
I am for the petitioner, my lords, serial number 7. I have given the representation to the PDO, my lords, state the petitioner's name in form number 9 and 11 and to issue e-Kata as per court decree. Court decree, my lords, is in annexure A.
ಸೇವ್ ಮಾಡ್ರು. ನಾನು ಅವಾಗೆ ಮಾಡಿದ್ದು ಇಲ್ಲಿ ಇಟ್ ಬಿ ಇನ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್.
Lords, it is innocuous prayer.
2204 ಹಾಕೊಳ್ಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 7.
My lords, it is innocuous prayer. Compromise decree entered between the elders. Innocuous prayer, my lords. Notice may be dispensed.
What do you mean notice may be dispensed?
Innocuous.
We'll have to find out why the PDO is not making the Kata.
And direct.
Huh?
Innocuous prayer. Please, my lords.
We should notice,
Date
let
may,
them
date
come.
may be fixed.
Yes,
Panchayat is concerned.
Nodre, why they are not making the kata
I
in terms of the compromise decree?
get an instruction now.
You are taking notice, is it?
Yes, sir.
Learned Counsel Sri
MS Devraj.
MS Devraj takes notice for respondent number 3.
Yes.
Learned Counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA as well as Learned Counsel for respondent number 3. Next para. Learned Counsel for respondent number 3 is directed to find out from the third respondent as to why the kata is not made, although the petitioner is seeking the registration of kata on the basis of a decree passed by the competent civil court. Yes. Release this matter
2 weeks.
on
2 weeks.
11th of June.
Oblige.
Serial number 8. Nataraj Ji.
Regarding this encroachment.
Yes.
The petition notes is owner of a land to the extent of notes 2 survey numbers 51/3 and 51/5. But it is subject to notes suit for partition, and it is also notes of final decree proceedings is also notes is pending. Notes without any notes of procedures of acquisition, not the portion of a land of this particular two survey numbers notes have been acquired with the respondent. In which notes I sought notes under RTI, under which provision of law, under which notes process of law note they have been acquired.
Acquired.
Acquired at the notes they say.
You made use of.
I made use of it.
It is not a local body matter. Land acquisition matter.
Italy corporation, Mangalore City Corporation ಆಗಿರುತ್ತೆ.
If your allegation is that the corporation has made use of your property.
Please.
And what is your prayer?
Notes, if at all, if they have, assuming for a segment they have acquired, let them pay the compensation. To the extent of notes, whatever that has been acquired.
Land acquisition matter ಆಗುತ್ತೆ. Local bodies ಹೆಂಗಾಗುತ್ತೆ?
ಇದು city corporation ಆಗಿರಿಂದ, but I made an application on RTI, which they say that it has not been acquired. Acquisition proceedings ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು they admitted.
Restore the lands ಅಂತ ಕೇಳಿದ್ರು.
Or otherwise not.
Restoration you have sought for.
Or otherwise not
Civil court,
compensation.
sir.
Or otherwise compensation.
Huh?
Or otherwise not compensation.
Land acquisition.
ಅಲ್ಲ,
ಎರಡು ಬರೋದಿಲ್ಲ ಇಲ್ಲಿ.
That's the reason notes I produce the authorities, in which they say notes the
So therefore, it will be a land acquisition matter, sir.
acquisition.
If you are openly saying that they have made use of my property, direct them to give compensation, then it's a land acquisition matter.
The authorities clearly say that illegally, if the authorities notes have taken the property of private persons, not they notes I am entitled for the either restore the land, notes or notes entitled for the compensation.
That becomes a subject matter of a land acquisition roster.
Please.
ಅಲ್ಲ ಪ್ರೇಯರ್ ಇಲ್ಲ ಬರೀ ರಿಸ್ಟಾರೇಷನ್ ಕೇಳಿದ್ದಾರೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೇಳಿಲ್ಲ.
ಹಂಗಂದ್ರೆ ಸಿವಿಲ್ ಕೋಡ್.
ಅಲ್ಲ ಆಲ್ಟರ್ನೇಟಿವ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದನ್ನ ಅದಕ್ಕೆ ಅಥಾರಿಟೀಸ್ ಯಾಕಂದ್ರೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ authorities say that yes, if they are legally acquired, they have to restore it back.
AGA takes notice for respondent number 1. Who appears for this Mangalore City Corporation? Notary ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಡೈರಿಲಿ ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? ಹರೀಶ್ ಭಂಡಾರಿ. Learned Counsel Sri Harish Bhandari is requested to take notice for response number 2 to 5. Learned Counsel for petitioner is directed to serve a copy of the petition along with annexures on Learned AGA and Learned Counsel for the respondent Mangalore City Corporation. ಆಮೇಲೆ ಕರೀರಿ. Please follow.
Serial number 6, Jagdish DC.
Has made a representation to the Gram Panchayat and also executive officer to make certain corrections in the Kata. The schedule of one Muddu Shetty and the property of Muddu Shetty and also the schedule of house property of one and same. Therefore, by mistake, my house is situated certain number 166. Whereas the house of one Muddu Shetty is situated certain number 159. But the schedule in his the Kata and also schedule in my Kata is same one and same. It is wrongly mentioned. Therefore, I have given representation to the Gram Panchayat seeking correction in the
Kata issued to me, they have not taken any steps in this regard.
Mr. Nagaraj, MS Nagaraj.
I will take notice to you.
Issue notice to the respondents. The petitioner is also permitted to serve a copy of the writ petition along with annexures on learned counsel Sri MS Nagaraj. Yes.
Please.
It's serial number 6.
Serial number 9, PV Vidyulata.
For the petitioner, my lords, the petitioner is a member of the third respondent society. He has purchased a site, my lords, which is approved by the first respondent authority. Site has been released, sale deed after the release order. Now they have not issued Kata in favor of the petitioner, my lords, in spite of repeated representations. They say there is a dispute pending in respect of the lands. My lords, the petitioner has made all inquiries. There is no dispute in respect of any part of the layout plan, my lords. They need to issue Kata in the name of the petitioner.
Mooda will issue Kata, is it?
Yes, my lords. Then it will be transferred to the Mysore City Corporation.
Learned counsel Sri TP Vivekananda is requested to take notice for response number 1 and 2. Issue notice to respond number 3. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on learned counsel Sri TP Vivekananda.
Obliged.
Serial number 10, Leela P. Devadiga.
I appeared for petitioner. I am the member of the Grama Panchayat. Your Lordship, thereafter I submitted resignation letter on 25/11/2022, my lord. Then your Lord, in terms of the section.
All the 3 of them.
All 3 of them.
All 3 of them.
Yes.
Huh.
Thereafter, I withdrew that because under section 43 of the Panchayat Raj Act, your Lordship, because once the resignation is submitted and member would be entitled to withdraw it within the 15 days. Within 50 days, I withdraw it. In spite of that, your Lordship, the president of the Panchayat, he takes a decision and issues an endorsement saying that my resignation letter is accepted. That is what I challenge before this. This court has already granted a stay.
In this matter.
Yes, sir.
Then why is it coming for preliminary again and again?
My lord, so. And other side, they were caveat and they were heard. The fifth
pass ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
Why it is
ಅದು
coming
orders
for
ಬಂದು.
hearing?
He is the contesting respondent. Fifth is contesting.
The senior is not in station. Seek for a short accommodation.
This is Gram Panchayat. You are appearing for?
3 and 4, madam. 3 and 4. Executive officer and
PDO.
development officer.
PDO.
3 and 4.
There are totally 4 members, they filed a resignation letter. And only out of 4, they, instead of 3 of them are concerned, they accepted it.
The Gram Panchayat should be normally represented by the PDO.
Yes, my lord.
You have shown the Gram Panchayat as represented by the president.
No, PDO also made party.
ಗೊತ್ತಾಯ್ತು. Just because you are contending that the Adhyaksha of the Gram Panchayat has accepted your
Yes, resignation.
resignation.
That's why I come before.
ಅವ್ರನ್ನ separate ಆಗಿ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
I'll make.
It's a legal entity. Gram Panchayat, in terms of the Panchayat Raj Act,
Yes, sir.
has its own seal. It's an authority and it is always represented by the PDO,
Yes, my lord.
who is appointed by the government.
Comment.
So Gram Panchayats are not represented by the elected representatives.
That's true.
So if you have any contentions to be made or allegations to be made against president, ಅವ್ರನ್ನ separate ಆಗಿ party ಮಾಡ್ಬೇಕು ನೀವು.
I'll make him as a party, my lord.
Anyway, notice issue ಮಾಡಿದಾರೆ ಆಗ್ಲೇ.
ಹೌದು, notice issue ಆಗಿದೆ. In fact, the 5th respondent was heard, my lord. He was caveat and he was heard.
You have not filed objections?
My lord, I have not filed objection.
ಇಲ್ಲ,
They have filed.
petition ಹಾಕಿದ್ದಾರೆ.
We'll have it next week then. We will hear and dispose of.
Please, Your Lordship.
Immediately.
At the request of learned counsel for respondent number 5, release this matter on 11th of June.
Obliged.
Yes.
Grateful, my lord.
Serial number 11, Mohammed Tahir.
The petitioner, my lord, is an elected member of the Davargire Gram Panchayat in the year 2020, my lord. The respondent number 6, my lord, who was the last candidate against the petitioner, filed an election petition on the ground that, my lord, there was a counting was not taken place, all those things. There's also one more ground, my lord, which says that I have not disclosed my criminal antecedents in the affidavit. My lord, that was one of the pleading, my lord. But the issue framed, my lord, by the election petitioner is that, my lord, that your issue, your lordship will get that at page 30, my lord. Page 30.
The election petition is allowed, is it?
Yes, my lord.
Is allowed.
Yes, it is allowed.
Ah.
My lord, the issue is framed is whether the petitioner proves that the respondent number has not counted the votes as provided under law. This is the issue, my lord. Now, my lord, the main ground which they have urged is under section 19, my lord, if the lordship sees in section 19, they say that I have not complied, non-compliance of act and rules, provisions of act and rules, because, my lord, I have not disclosed, my lord, the criminal actions. My lord, in the rules, as well as in the act, my lord, there is no provision, my lord, which says that I have to disclose the criminal case pending against me. Yes, my lord, in RP Act section 33A, it says, my lord, but my lord, this petition is filed under the Gram Swaraj Act, which there are section 15 and 19, does not have any rules or an act prescribes that I should, my lord, disclose the criminal case pending against me. The nomination papers, my lord, which is prescribed under the rules, my lord, the Gram Swaraj Act also does not prescribe the nomination. There is no such. But, my lord, during the nomination papers files, they have prescribed one format saying that you have to submit 2 affidavits stating that these are the format.
Yes.
But it is not, my lord, supported by any act or rules or guidelines.
So,
Like, my lord, in the RP Act. My lord, now what has happened, my lord?
if it is found that there is a prescription, you are required to file a certain information by way of an affidavit, and you have not filed it.
I have filed it, my lord.
Then,
I have filed it an affidavit.
ah,
What I have not, my lord, there is a column in the affidavit.
yes,
Which says that whether I have a criminal case or not.
yes,
Which I said no.
yes.
My lord, that has not been, my lord, in RP Act, my lord, they say that I have to disclose.
Sodri,
My lord, now,
you cannot succeed on a technical ground
yes.
that there is an express provision in the RP Act, but there is no such provision in the Panchayat Raj Act.
Yes, that is one of the ground, my lord. Now, what has happened, my lord, the fact is, now after they filed, my lord, there is no original documents of called for. The prescription says, my lord, that the format, I have to file 2 affidavits of the originals, which is prescription. My lord, the respondent number 6 filed a petition. The court has not called for the records. In fact, there was a part on fault of my lord, which is not contested properly. After the client has come to my office, I have said, when I asked him, he said, no, I have disclosed whether I don't know how it has not come. Then I asked him to, my lord, apply the certified copies. He has applied the certified copies, my lord. He has filed 3 affidavits. In 3 affidavits, my lord, the last affidavit, when he went to for filing the nomination, he has been pointed out that you have to disclose it. Then he filed a 3rd affidavit. That is a part of the record, my lord, which is there in the elections office. I have applied for certified copies and now I have obtained. My lord, by way of an amendment, my lord, amendment of petition, I have produced that. The lordships will get that, my lord. The petition, amendment petition, which is filed. My lord, page 7, my lord. This is I have applied for certified copies, my lord. And the election officer has given me, my lord, this is my nomination paper, next page.
Yeah.
My lord, there are 3 affidavits, my lord. First affidavit, my lord, is at page 10.
Yes.
there, my lord, your lordships will get that column at page 15. Page 15 ali, serial number 5, my lord, which says that I have to disclose the criminal. First, I have to file these two, my lord, affidavits, same originals. This second affidavit is at page 17, my lord. Page 17. Similar affidavit. Now, when they have pointed out that I have to, my lord, pending close, that your lordships will get at page 24. In that, my lord, this is a third affidavit. My lord, at page 29, my lord. Serial number 5B. I have disclosed, my lord. Sanction number 6 of 2016. It is part of it is available in the election of, with an election officer. This affidavit was not produced, my lord. The entire documents was not produced by the respondent number 6 before the election petition. They have produced the certified copies, and based on that, my lord, it is actually my fault also, my lord. I should have called for the records, or I should, the poor contest, my lord, he could not. After obtaining the certified copies, my lord, I came to know actually I have disclosed, my lord. It is part of the record. My lord, it is a case for remand, my lord, to again revisit the evidence. ಮಾಡೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಇನ್ನೊಂದಿತ್ತು ಮಾಡಿದ್ದಾರೆ.
Please get the original records.
Please, Lord.
The Tahsildar is the person who has the custody of the original documents.
Plus, this is not even issued by the Tahsildar. Tahsildar paravagi anta ಬರ್ದಿದ್ದಾರೆ ಯಾರು.
Okay, no, let us get the original records.
And my lords, kindly note, this is the second round, my lords. The previous round, my lords had only passed the order. ಇದರಲ್ಲಿ. My lords,
However, this contention was
my
not
lords,
raised.
never this contention is taken. Rather, the contention taken is very specific.
Why I said, my lord,
My lords, contention is very
it is not-
specific
it is not
that
properly contested.
ಏನ್ ಮಾಡೋದು?
law does not provide for this.
I don't know.
They have
where you
rather-
got this now.
They have rather
But
made
I
the
have applied,
statement, my
my lord, I
lords,
have applied
that
and got it. That's why
even
have
if I
produced
have,
that by way of an amendment, I have produced it, my lord, as saying that where I have applied. Lordships will get that at my.
and Astella, I request my
Page
lords,
7. No, if disclose ಮಾಡೇ ಇಲ್ಲ ಅಂದ್ರೆ I have no place, my lord. They are Gram Panchayat members.
Well, when was this order passed?
My lord, the order passed, my lord, the impugn order is passed.
The matter was remanded, is it? Last.
my lords,
No, no,
please,
no,
my lords,
no,
my lords,
no.
what had happened, my lords, they had filed an application for rejecting my application itself,
That was
election
different.
petition, on the ground that this is not a ground on which an election petition could be filed, and I could not have sought for disqualification or for challenging his election to be, for his return to as a candidate who has
Petition
returned.
was dismissed.
That was dismissed, my lords. We came before this honorable court. My lords have passed an order, my lords.
Abhay,
Dated
that
26.
petition was dismissed.
Writ petition was allowed and matter was remanded back because my election petition was dismissed.
It was dismissed.
My election
That
petition
was
was
for a
dismissed
different-
on his application, and the application is filed on the very main ground, only one ground, that non-disclosure of criminal antecedents is not a ground for seeking for disqualification or for that matter for challenging the election which has been held. This has been throughout the case which has been taken up by the petitioner here in my lords. At no point in time it was the case that something has gone wrong where I had submitted. ಅಷ್ಟೇ ಅಲ್ಲ, ಇವಾಗ ಅವ್ರೇನ್ application ಹಾಕಿದ್ದಾರೆ, I request my lords to kindly have page 31. Page 31 ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ನಲ್ಲಿ ನೋಡಿ, ಈ ಘೋಷಣಾ ಪತ್ರದ ಜೊತೆಗೆ ಅವ್ರು ಏನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅದರಲ್ಲಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಲ್ಲಿ ಘೋಷಣಾ ಪತ್ರ, ಅಫಿಡವಿಟ್ 2 ಒರಿಜಿನಲ್ 1 ಜೆರಾಕ್ಸ್, ಒಟ್ಟಿಗೆ 3.
ಯಾವ್ದು ಪೇಜ್ ನಂಬರ್?
Page 31 ಸ್ವಾಮಿ ಅವರ ಅಪ್ಲಿಕೇಶನ್ ವಿಚ್ ಹಸ್ ಬಿನ್ ನೌ ಫೈಲ್ಡ್ ಫಾರ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಏನ್ ಕೇಳಿದ್ದಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಲ್ಲಿ ದಿಸ್ ಇಸ್ ನಾಮಪತ್ರ ಜೊತೆಗೆ ಸಲ್ಲಿಸಬೇಕಾದ ದಾಖಲೆಗಳು ಏನೇನಿದೆ ಅನ್ನೋದು ಹಾಕಿದ್ದಾರೆ ಅವರು. ಘೋಷಣಾ ಪತ್ರ, ಅಫಿಡವಿಟ್ 2 ಒರಿಜಿನಲ್ 1 ಜೆರಾಕ್ಸ್, 3 ಒರಿಜಿನಲ್ ಹಾಕೋ ಪ್ರಶ್ನೆನೇ ಬರೋದಿಲ್ಲ ಅದರಲ್ಲಿ. They are now taking up an entirely new contention that I had submitted 3 affidavits, which is not even permissible.
I may point out, my lord. Returning officer, my lord, has every right, my lord, to point out that there is a defect. He has pointed out. he has pointed out that you have to file one more affidavit disclosing this time. That time I have filed. My lord, whether he takes it 3 or 2, my lord, I don't know. I have given it and it is a part of record, my lord. It is a part of record. What is, my lord, the law says the prescription? I have to disclose. My lord, I have disclosed it. Now I have taken a certified copy, though it is a mistake on my part, my lord, should have applied and I should have done it.
No.
Lord, if the
What
returning
is
office,
the requirement? The same affidavit
please,
in original and duplicate has to be filed, is it?
please.
2 originals I have to file.
Huh?
Same affidavits, 2 originals I have to file. Yes, my lord. I have filed 3 originals.
How?
My lord, 2 originals when I filed, my lord, they said, my lord, there is, I have not disclosed one column which says that I have to disclose criminal aspect. You have not disclosed, you please give it. So then again, my lord, immediately on the same day, immediately after 5-10 minutes, my lord, I have given that affidavit saying disclosing the.
ಅದನ್ನು ಕೊಟ್ಟಿದ್ರೆ ಅದೇ 2 ಕೊಡಬೇಕಾಗಿತ್ತು. Not possible, sir.
My lord, that is only.
You knew all this.
My lord, it is.
You knew all this. That is why you have not insisted on getting the original records.
No.
Otherwise, you would have said. And you would not have raised this ground at all.
Well, this was not a ground.
Earlier, you could not have raised such a ground.
Lord, in fact, my lord.
If you had mentioned it, then why would you contend that no, there is no such requirement and therefore I am not disclosed?
I have only denied, my lord, contention. I have not contested at all. Lord, now, my lord, since I have disclosed, Lord, the Supreme
Please
Court.
file statement of objection.
They will file minutes.
Three weeks time is granted to the respondent.
Please.
Notice ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ sir.
Learned AGA takes notice for response number 1, 3 and 5.
5th, I am non-ident. Private respondent.
Private respondent is 6.
I'm sorry. Sir.
ಇದು ಎಲೆಕ್ಷನ್ ಕಮಿಷನರ್ ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ? ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ ವೈಶಾಲಿ ಹೆಗ್ಡೆ.
ವೈಶಾಲಿ ಹೆಗ್ಡೆ ಅವರು ಅಪೇರ್ ಆಗ್ತಾರೆ.
ಏನ್ರಿ ಇದು ಏನನ್ನ ಬರ್ದಿದ್ರಲ್ರಿ? ಏನ್ರಿ ಇದು ಆನರಬಲ್ ಕಲೆಕ್ಟರ್?
That is the they have made like that only, my lord. The respondent number 6 in the petition, my lord.
ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ.
If I make something else, my lord, office will raise objection. That is how it is.
AGA for 1 and 3 to 5. Learned counsel Srimati Vaishali Hegde is requested to take notice for respondent number 2. Learned counsel.
I'm on caveat for R6.
Sri M. Rudraya
This means I'm on caveat.
has entered appearance for respondent number 6. Please. Full stop. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA as well as learned counsel for respondent number 2. ನಿಮ್ಗೆ ಬಂದಿದೆ. Full stop. Next para. Although it is the contention of the petitioner that he seeks to produce the all-important document, namely an affidavit disclosing the criminal antecedents, by filing an interlocutory application in IA number 1 of 2024. For amending the writ petition and adding additional facts and bring on record the additional documents, the learned counsel for the 6th respondent has stoutly defended the stoutly sought to defend the impugned order impugn judgment. While pointing out that earlier when the election petition was dismissed,
Please.
the sixth respondent had approached this court in WP number
24065 of 2022.
which was later allowed.
Please, may I pass on?
Put it.
Sir. Is order 7 to
Remanding the matter back to the senior civil judge to recommence the proceedings from the stage before taking up IA number 5. Full stop. It is submitted that the contention of the petitioner that the non-disclosure of criminal antecedents would not amount to correct practice was rejected by this court. Full stop. Learned counsel would therefore submit that the petitioner had all the opportunity to produce the certified copy of the affidavits if he had already filed disclosing the criminal antecedents. Full stop. On the other hand, for the first time, such information is sought to be brought on record. Full stop. The next para. Tahsildar, Jaglur Taluk. May have to verify the original records and make a specific statement regarding the affidavit said to have been filed by the petitioner. Full stop. For that purpose, 3 weeks time is given to the respondents to file statement of objections. Yes.
Number 12,
Wait.
Somanna KP.
For the petitioner, my lord, counsel on record is out of town. Time may be. Counsel on record is out of town, a week's time may be.
There is no interim prayer. Why are you not asking for notice to be issued?
Haven't received instructions. Clarified.
Learned AGA takes notice for respondent number 1. Learned counsel Shri TP Vivekananda is requested to take notice for response number 2 and 3. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA as well as learned counsel for respondent number 2 and 3.
Number 13, Prabhu Rao CB.
Yes.
Respondent number 1 has issued an order which is
Huh?
not yet implemented. As per Annexure B, my lords, an order is being passed on 8/7/21 for demolishing an illegal construction which is being upheld by respondent number 2, my lords.
Huh.
The order is not implemented, my lords.
various representations has been given by the petitioner, my lords. Annexure A is the notice which is being issued by respondent number 1 to respondent number 2, my lords, seeking explanation regarding the illegal construction, my lords. Annexure B is the order, my lords. In page number 18, my lords.
February 2022.
It's a 21 order, my lords. In page 18. Antima Adesha.
Annexure B is dated 3/2/2022.
My lords, part of that is at the next page, my lords.
8/7.
21, my lords.
Issue notice to the respondents.
Bill number 14, Nagaraj RC.
For the petition. Without acquisition proceeding, the Patra has been issued without giving any compensation to the petitioner. Without acquisition proceeding, Patra has been issued. In similar matter, Lord, without acquisition proceedings, the land has,
Akkupatra
has been issued to the seventh respondent. Give any compensation, no compensation. In a similar matter, Lord, the petitioners are saved. Notice has been issued, interim order has been granted. Petitioners are saved. Similar matter. There are two matters. Writ petition number 12180 of 2024. Writ petition number 6106 of 2020.
that again is based on another order. They are referring to another order, WP number 6106 of 2024.
There are two.
Dated 23/2024.
The petitioners are same. Any changes, Lord, it is subject to result of the writ petition there. On the basis of the Patra, Lord, they issued the e-card. Next, F blood. They have given an endorsement that land has not been acquired.
Authorized is of the year 1975.
In 1975 ಇಂದ ಅವರು ಜಾಗದಲ್ಲಿ ಇದ್ದಾರೆ. What is this?
ಇಲ್ಲ, without, kindly see the annexure, yes, without acquisition proceeding, ಹೆಂಗ್ ಹಕ್ಕುಪತ್ರ issue ಮಾಡಕ್ಕೆ?
You can't challenge that in a writ petition, sir.
ಅಲ್ಲ ಸ್ವಾಮಿ.
And you have suffered an order at the hands of the civil court.
That is a permanent injunction.
ಅದೇ
That is an injunction.
ಹೌದು.
ಅಲ್ಲ ಇಲ್ಲಿ.
You are not seeking for a declaration.
Without giving.
Have you sought for a declaration?
ಇಲ್ಲಿ.
Then?
No, it is, still it is my name.
ಅದೇ you come to the high court directly file a writ petition.
ನಾನು acquisition proceeding ಇಲ್ದಲ್ಲ ಹೆಂಗ್ ಮಾಡಕ?
Therefore, you had the right to seek a declaration that the land is not acquired, the land belongs to me. The authority, whoever it is, the deputy commissioner or the tahsildar would not have issued akkupatra to them anbuttu. You should have sought a declaration.
They themselves have.
ಈಗ ಏನಾಗುತ್ತೆ, there are conflicting orders now. A civil court has granted an injunction against you.
It is in respect of permanent
Now,
injunction. And the basis of,
the only relief that is given to you, the interim relief is that they should not issue the Kata. ಅಷ್ಟೇ. ಅದ್ ಬಿಟ್ರೆ nothing else can be done here. What is used? That cannot be the final order.
Without acquisition proceeding.
That cannot be the final order here, sir. You don't want to seek a declaration. You are declaring for yourself, no, there is no acquisition. ಮತ್ತೆ from 1975 they are squatting on the property.
ಅಲ್ಲ ನಮಗೆ ಗೊತ್ತೇ
If someone is illegally squatting over a property, what you should do?
ಇಲ್ಲ, still it is in my position.
ಹಕ್ಕುಪತ್ರ ಗ್ರಾಂಟ್ ಮಾಡಿ ಅವ್ರಿಗೆ they have secured an order of temporary injunction against you, sir.
It is an open land. Nobody has.
They have secured an order of temporary injunction against you.
Yes, kindly see the annexure F without acquisition proceeding, the assistant commissioner.
So therefore, you are seeking a declaration now. You are seeking a declaration now at the hands of this court.
No, ನಮ್ಗೆ ಏನಾರ compensation ಆರ ಕೊಡು.
But that is not your prayer. Is that your prayer? Is that your prayer? Shall I record it?
That is why blood I challenge the Akkupatra.
From so many years, the litigation is going on before the civil court, and you now come to the high court, secure an order not to register the Kata in their name.
ಮತ್ತೆ ಅವ್ರು ಮಾಡಿದ ತಪ್ಪಿಗೆ
ಅವಾಗ ಯಾವುದೋ ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಾರೋ, so you want the same order. Again and again you are coming before the court. ಯಾರ್ಯಾರ ಹೆಸರಿಗೆ ಹಕ್ಕುಪತ್ರ ಮಾಡಿದಾರೋ ಎಲ್ಲಾದ್ರೂ ಸೇಮ್ ಆರ್ಡರ್ you are taking now.
ಅಲ್ಲ, I produce the sale deed. ಅಲ್ಲ, ನೀವು ಒಂದು ಹಕ್ಕುಪತ್ರ different ಹಕ್ಕುಪತ್ರ has been issued.
ಅದೇ by virtue of one order, now you are coming and again before this court. ಯಾರ್ಯಾರ ಹೆಸರಲ್ಲಿ ಹಕ್ಕುಪತ್ರ ಗ್ರಾಂಟ್ ಮಾಡಿದಾರೋ ಎಲ್ಲಾದ್ರೂ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ.
Petitioners
Don't issue them the Kata.
Petitioners are same. I have purchased the land in 1963.
Therefore, you should have succeeded before the civil court.
I have produced the sale deed.
You are not seeking for a declaration. Now you are indirectly seeking a declaration at the hands of this court.
This is without acquisition proceeding. How can I issue the Akkupatra?
Therefore, that should have been your challenge. If someone is squatting over your property on the basis of some order passed by some revenue authority,
the question is with us.
There is an interim order against you, sir. How can you contend like that? Barkade. Learned AGA takes notice for response number 1 and 2. 1, 2, 5 and 6. Issue notice to response number 3, 4 and 7. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that the petitioners have obtained an interim order at the hands of this court in WP number 6106 of 2024 and 12180 of 2024. The learned counsel prays for similar interim relief. We stop. Next para. Having regard to the interim orders passed in the said two writ petitions, comma, while directing the fourth respondent panchayat development officer of Kotalwadi Gram Panchayat not to register the Kata, comma, if not already done in favor of the seventh respondent. Yes.
Serial number 15, Naveen JN.
For the petitioners. The first petitioner is the owner of the Lordship property, 33 guntas. He succeeded the property. Lordship, as per Annexure E, page 39, Your Lordship. Applied for the conversion of the land. Lordship converted, and the layout plan is also approved. Farmed the sites, Your Lordship. He has sold certain sites in favor of the parties, and he has retained some sites in his favor of the first petitioner. Such being the case, my Lordship, an appeal under section 306 was filed before the Deputy Commissioner, challenging the Kata standing in the name of the petitioner as well as the site owners, Your Lordship. And there was an interim order granted by the Deputy. But it's third parties, Your Lordship. Just like a public interest litigation, they have challenged the Katas after lapse of 15 years. But the Deputy Commissioner granted an interim order, against which, my Lordship, I filed a writ petition, page 61, Your Lordship. And this Honorable Court has granted an interim order. And Katas were continued in the names of the petitioners, Your Lordship.
You want similar orders?
No, Your Lordship. No, Your Lordship. The next page, Your Lordship, kindly see. I entered into a lease agreement with the second petitioner. My Lordship, she is the wife of the first petitioner. Page 62. The lease deed has came to be executed by the first petitioner in favor of second petitioner for establishment of an industry, Your Lordship. I obtained a license and also from the municipality. For BESCOM connection, Your Lordship, I have obtained an NOC from the municipality. Your Lordship may come to page 82. This was issued on 17/11/2022. It will be in force for 6 months, Your Lordship. Again, it was renewed on next page, my Lordship, page 83, on 17/5/2023 for another 6 months. But I have not completed the, my Lordship, industry due to, my Lordship, the loan was sanctioned, Lordship, page 78, Your Lordship. On 22/22.
Same layout.
Same layout, Your Lordship. Same layout.
You don't need to get it converted for industrial purpose.
Hello, Kelo sites
You can do whatever you want.
No, industry, my Lordship, it is.
Even a site, a residential site layout. Who is the you are not obtained any sanction from the competent authority.
The municipality have obtained, Your Lordship. Because
is the municipality the competent authority for sanctioning the layout?
4 site ಅಲ್ಲಿ ಇಂಡಸ್ಟ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ ಇದು Lordship, the ಮಸಾಲಾ ಪೌಡರ್ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಮಾಡುವಂತದ್ದು. ಪಕ್ಕದಲ್ಲೆಲ್ಲ
ಇಂಡಸ್ಟ್ರಿ ಸರ್.
ಪಕ್ಕದಲ್ಲೆಲ್ಲ ಇಂಡಸ್ಟ್ರಿ ಇದೆ.
Whether you like it or not, it's an industry.
Industry, it is industry Lordship. ಪಕ್ಕದಲ್ಲೂ ಇಂಡಸ್ಟ್ರೀಸ್ ಇದೆ. For that Lordship, municipality.
Conversion order ಬೇಕಿಲ್ಲ.
Conversion order.
ಯಾವ್ದಕ್ಕೆ ತಗೊಂಡಿದ್ರಿ conversion order ನೀವು?
ನಾನು ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಇಂದ ನಾನು ಕನ್ವರ್ಷನ್ ಆಗಿ ತಗೊಂಡಿರೋದು ಫಾರ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಪರ್ಪಸ್.
ನಾನ್ ಅಗ್ರಿಕಲ್ಚರಲ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಪರ್ಪಸ್.
Residential purpose.
Then
commercial.
How can you put up an industry?
The municipality has given NOC.
ಅದೇ ನಿಮ್ಗೆ ಯಾವಾಗ ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡಿಸ್ಕೋಬಹುದು. ಅಲ್ಲಿ ಸ್ವಲ್ಪ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ರೆ ಮುಗ್ದೋಯ್ತು.
ಆಲ್ರೆಡಿ ಅಲ್ಲಿ ಇಂಡಸ್ಟ್ರೀಸ್ ಇರೋದ್ರಿಂದ ಪಕ್ಕದಲ್ಲಿ ನಾನು ಇಂಡಸ್ಟ್ರಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
You don't have to follow any rules, regulations, nothing is it.
But they have issued an NOC.
What is the purpose of the Karnataka Town and Country Planning Act?
I do agree, Your Lordship.
There should be a planned development.
Yes.
You cannot do whatever you want in whichever place you want, just because you are the owner of the property.
So they have issued NOC. I'm seeking only renewal of NOC to obtain BESCOM supply, Your Lordship.
ನಿಮಗೆ ಧೈರ್ಯ ಬಂದ್ಬಿಡ್ತು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಬಂದಿದ್ದಾರೆ ಒಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ.
ಇಲ್ಲ ಅದರಲ್ಲಿ
That was for residential purpose.
Lordship, that is in respect of Kata's, Your Lordship. It
is for residential purpose.
Residential purpose. Now the
Now
contention.
you want to establish an industry.
No, Your Lordship. The reason to produce
without even getting an order of conversion.
The reason, Your Lordship.
You not get an order of conversion for using agricultural land for industrial purpose.
Agriculture in the convert agide.
ಆಯ್ತು ರೆಸಿಡೆನ್ಷಿಯಲ್ ಕನ್ವರ್ಟ್
Residential
ಆಗಿದೆ. ರೆಸಿಡೆನ್ಷಿಯಲ್ ಪ್ರಾಪರ್ಟಿನ ಇಂಡಸ್ಟ್ರಿಗೆ ಯೂಸ್ ಮಾಡ್ಬೋದಾ?
ಟೌನ್ ಅಂಡ್ ಕಂಟ್ರಿ ಪ್ಲಾನಿಂಗ್ ಆಕ್ಟ್ ಕಡೆಗಡೆ ಪರ್ಮಿಷನ್ ತಗೋದು. ಇಲ್ಲ ಅದು ಖಾತಾ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದಕ್ಕೆ ಈಗ ಮುನ್ಸಿಪಾಲಿಟಿ ಅವ್ರು ಏನ್ ರೀಸನ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ ಆ ಖಾತಾ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದ್ರಿಂದ ನಿಮ್ಗೆ NOC ರಿನ್ಯೂ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಇದ್ದಾರೆ. ದಟ್ ಈಸ್ ದ ರೀಸನ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ದಿ ವರ್ಷದ ಇಂಟ್ರಿ
Not
ಮಾಡೋ
be done, sir.
they have issued
Unless you get the land converted to industrial purpose, they could not have even given the NOC.
ಕೊಟ್ಟಿದ್ದಾರೆ ಲೈಸೆನ್ಸ್.
ಎಲ್ಲ they'll also ignore all the requirements of law.
The loan disperse ಆಗಿದ್ದು ಲೇಟ್ ಆಗಿದ್ದಕ್ಕೆ my lordship I have given a representation.
State ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ನೀವು.
State my lordship. I have given a representation to the municipality my lordship to renew the NOC.
Caveat petition is it? ನೀವು
ಅಲ್ಲ ನಾನು notice was served on me, my lord. I am the
served
counsel.
on you. Yes, what are your instructions?
My lord, earlier 2 times they have given page 82 and 83, my lord, that it is not said industry, only BESCOM connection. BESCOM connection for your site, that is what it says.
NOC for the
And
BESCOM
after
power
that,
supply.
because DC passed the order, then they did not give the NOC. Later, that High Court stay order, it was not brought to our notice, my lord. Now he has brought to our notice.
You have stated in your memorandum of petition that you are using it for industrial purpose now?
Yes.
Then how can we ignore the provisions of law, sir? How can we now issue a direction to the municipality? No, give them the NOC.
It is a renewal of NOC, not a fresh NOC.
How the NOC was issued to you?
That is only for power supply, Your Lordship, not
Power supply for what?
for the industry.
They are not required to find out? ಯಾವ ಪರ್ಪಸ್ಗೆ NOC ಕೊಡ್ತಾರೆ ಅಂತ they don't have to find out? ಹೆಂಗ್ರಿ ಕೊಟ್ರಿ ನೀವು NOC?
ಮನೆಗೆ ಸ್ಲಾಶ್ ಅಂಗಡಿಗೆ ಹೊಸದಾಗಿ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ.
ಅಂಗಡಿ
ಮನೆ ಸ್ಲಾಶ್ ಅಂಗಡಿ.
ಅಂಗಡಿ
Page 82, 83.
Now he is claiming that he has got a trade license. You have issued also a trade license.
And KSFC loan also.
Ritwik Agro Industries. How did you get the NOC? Barkal. Learned Counsel Shri A.C. Chetan has entered appearance for the respondent. Town Municipal Council, Bagepalli. Full stop. It is the contention of next para, the petitioners, that the respondent TMC had issued a no objection certificate on 17/11/2022 for providing electricity supply to the industrial unit established and run by the petitioners. Full stop. However, subsequently, the respondents are declining to renew the NOC. Full stop. Next para. Learned counsel for the respondent submits that admittedly the petitioners have established an industry without getting the land converted to industrial purpose. Full stop. Directions have been issued by the deputy commissioner not to renew the NOC, and accordingly the respondents have declined to.
There is no such direction.
DC cancelled the Katas.
Katas ಬಗ್ಗೆ
After which
pending.
he filed another writ petition and obtained the stay order.
There's no direction from the DC, Your Lordship.
Allari, now why are you not renewing this one?
Now
because of
we are
the-
not aware of the stay order of the High Court, my lord, because the DC cancelled the Katas, so now they are not renewing the NOC.
So you are ready to renew it now?
If, because now the stay order is there,
So you are ready to renew?
that is subject to this.
Huh?
Subject to this writ petition.
ಏನ್ ಹೇಳ್ತಾರೆ? ಅದ್ ತೆಗ್ದಾಕ್ಬಿಡಿ. ಅದ್ previous sentence ಓದಿ. Unit. Without getting the land converted for industrial purposes. Full stop. Nevertheless, on instructions, it is submitted that the deputy commissioner had earlier passed orders directing the TMC to cancel the Katas. But it appears that the petitioner filed a writ petition and got the order of the deputy commissioner stayed at the hands of this court in WP number
12264.
12264 of
23.
2023. ಅದನ್ನ ನಾನು ಓದಿದ್ದು ಇವಾಗ.
Page 61.
But, if it is the contention of the petitioner that he has established an industrial unit without getting the land converted for industrial purpose, then the respondent TMC could not have issued such an NOC for granting electricity supply to the unit. Full stop. Learned counsel therefore submits that the respondent should be permitted to file statement of objections, meeting the averments made in the writ petition. Full stop. Next para. 2 weeks are granted to the respondents to file statement of objections. Yes.
Number 16, A. Shubhabar Mishra.
So I appear for respondent number 2. Let's kindly have it on Monday. I have informed the other side.
Monday.
At the request of the learned counsel for respondent number 1.
2, my lords. BVMP.
Respondent number 2, BBMP. Release this matter on 3rd of June.
Yes, my lords.
Grateful. Serial number 17, Swami Shivaprakash.
For the petitioner, madam. The petitioner is challenging the demand notice issued by the corporation, madam, demanding the property tax, madam. The petitioner is running a free hostel as well as the education institution. Madam, earlier the endorsement issued by the corporation, madam, granting exemption to the petitioner, madam, as per annexure D, madam. And also, madam, a circular came to be issued on 23/5/2003, 2000. 26/12/2003.
What is the latest now?
Also,
Line is-
educational, as
Huh?
there is an amendment brought
Huh.
into effect under section 152.
Yes,
Educational institutions are exempted.
exempted.
But what has happened here is, my lordship, the amendment came on 10/3/2023. Earlier, there was no exemption when the BBMP Act came into force. So from 11/1/2021 till 10/3/2023, for those 2 years, that is a question which is still to be decided. The other writ petitions are pending, my lordship.
Huh?
The other writ petitions challenging the same issues are pending.
Interim orders are passed.
Interim orders are passed.
Put it.
This matter has been allotted to Monish Kumar sir. He must have filed wakalat also.
Learned AGA takes notice for respondent number 1. Learned counsel Shri Monesh Kumar,
KB Monish. Kumar.
KB Monesh Kumar is requested to take notice for response number 2 to 4. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA as well as learned counsel for the respondent BBM. Full stop. Next para. Since interim orders of stay have been passed in similar matters, including WP number 1649 of 2024, dated 18/1/2024, the petitioner is also entitled for such interim orders. Full stop. Accordingly, there shall be an ad interim order of stay of the impugned demand notice,
Annexure came.
annexure K, till the next date of hearing. Until further orders. Yes.
Problems.
Number 18, Shiva Charanar.
For the petitioner. My lords, the petitioners herein are aggrieved by annexures A to L, my lords, passed by the respondent BDA, my lords, asking us to demolish a so-called violation, details of which are not forthcoming in the said notices. However, my lords, the fact of the matter is that BBMP is the one having jurisdiction over this property. Taxes and katas have been issued by the BBMP. Similar notices were issued by the BBMP earlier and are stayed at the hands of this honorable court. Now, my lords, the BDA issues the similar kind of notices on the behest of one of the residents who nurses certain personal grudges against these very petitioners, my lords. The BBMP petition, my lord, is the connected matter at 18.1.
In that one, interim order.
Interim order is passed by this honorable court in that matter, my lord. The petitioner is petitioner number 8 in this matter. In fact, there are 350 apartments, my lords, of the similar nature.
It is recorded that it's a temporary structure.
My lords, it is, these flats, my lords, are located in the first floor, my lords. What has happened is articles from the top floors fall on these ground floors, my lords, like glass, pots, cigarette butts, and so many incidents have happened in the past. For such reasons, my lords, these first,
In this order,
please, my lords.
it is recorded, it's a temporary structure.
Temporary structure, in the sense it's a sheet, my lords, to protect these first floor residents from those articles that are falling from the top floors, my lords. That is the structure that is referred to, my lords. In fact, it is not a permanent structure at all. It is a sheet that is placed, my lords. BBMP has considered that matter and that order is challenged before this honorable court. I'm aggrieved by the notices issued now by the BDA without jurisdiction, my lords.
Who had sanctioned the plan earlier?
My lords, the BDA had issued the sanction plan in 2006. Thereafter, my lords, in 2007, post 2007 jurisdiction.
Here in the notice,
Please, my
it
lords.
is stated, ಈ ಹಿಂದೆ ಪ್ರಾಧಿಕಾರದಿಂದ ನೀಡಿರುವ ಅನುಮೋದಿತ ನಕ್ಷೆಗೆ ವಿರುದ್ಧವಾಗಿ ಫ್ಲಾಟ್ಗಳನ್ನು ವಿಸ್ತರಿಸಿ ನಿರ್ಮಾಣ ಮಾಡಿ ಉಪಯೋಗಿಸುತ್ತಿರುವುದು ಮತ್ತು ಮಂಜೂರಾತಿ ನಕ್ಷೆಯಲ್ಲಿ ನಿಬಂಧಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿರುವುದು ಕಂಡು ಬಂದಿತ್ತು. Means they had issued the
They had
sanction
issued,
earlier.
please, my lords. Post which,
What is the sanction that was earlier given by the BDA?
my lords, the sanction plan, it is according to the sanction plan, my lords.
Here, BDA is saying,
Please, my lords.
ಈ ಹಿಂದೆ ಪ್ರಾಧಿಕಾರದಿಂದ ನೀಡಿರುವ ಅನುಮೋದಿತ ನಕ್ಷೆ means
My lords, the earlier sanction plan, these buildings are in the apartment premises, my lords, which is Purvankara projects, my lords.
at any point of time,
Is-
was there any sanction accorded by the BDA?
Please, my lords, it was
What is that?
accorded in 2006, my lords.
Ah,
Post 2007, my lords, the jurisdiction was handed over to the BBMP.
hmm.
Post which BBMP is.
The allegation
taking-
is
Please, my lords.
you have made constructions contrary to the plan sanctioned by the BDA.
Please, my lords, the details of that
Therefore,
are
that's
not,
why they have issued notice to you now.
my lords, the details
Can't
of it
contend
are
that
not,
they have no jurisdiction.
my lords, the
If there is
details
a
of,
violation of the plan sanctioned by the BDA, then who is to take action?
my lords, in fact, the same set of facts, my lords, the BBMP is also dealing with the exact same set of facts, my lords.
Madam, you have given a different version here. That is what is been recorded. If that is the case, then there is no difficulty. But that is not the ground on which the present notice has been issued by the
No,
BDA.
the present notice doesn't,
You can't claim the same benefit.
my lords, it is the
It
same,
was contended before this court in the other writ petition that you have only put up a temporary sheet
please,
to protect the residents
Please.
from something falling on their head.
please,
But
please.
that
my
is not the tenor of the notice, impugn notice, which is
lords,
in
the
this
impugn
writ petition.
notice doesn't say of what violations, they speak of a spot inspection on 19th of February.
Yes.
The notice or an intimation was never
Then
given to
You
us.
will have to go and answer.
My lords, it was never
How,
given,
why are you coming before this court on a notice?
my lords, the intimation of such inspection was never given to us. There was no
Madam,
records
this is
in our,
only a notice. Is there any order passed?
not, no, my lords,
Then-
there is a final notice that is issued to the association in
Then
fact.
even
my
after
lords.
issuing notice, if you don't go before the authority, then what will they do?
We have responded to these notices, my lords.
Ah.
In fact, there's a final notice that is issued to the association, my lord.
Ah.
On 12th of, on the same date, my lord, 2nd of, which is found at page number 30, my lords.
Yes,
Page number 30 and 31.
yes.
This was issued to the association, my
Correct.
lords, with regards to the same flat numbers, my lords,
Ah.
wherein they have instructed us that the possession certificates would be cancelled, my lords.
Yes.
Aggrieved by these notices, my lords, we have approached this honorable court.
But why have you not given a reply?
My lords, replies have been issued, my lords.
Where is it?
Reply, my lords, is found at page number 27, my lords.
Yes.
In fact, page number 29 speaks of the fact that there was no alleged spot inspection that was made. There are no records found in the apartment premises of any official coming and visiting the premises at all, my lords.
Learned AGA takes notice for respondent number 1. Notice has been issued?
No, my lords.
Lord, I appear for the respondents number
BDA.
2 to 4 in
BDA.
BBMP, my lord, in 18.1. 18.1.
Learned counsel Sri K. Krishna. is requested to take notice for respondent number 2 and 3. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA and learned counsel for the respondent BDA. Stop. Next para. Learned counsel for the petitioners submits that in the connected writ petition, the very same petitioners,
One of the petitioners, my lord. Petitioner number 8, my lords, in item number 18, she is petitioner number 8. For the reasons, my lord, the same complainant had approached BBMP earlier.
filed by one of the petitioners herein, namely petitioner number 8, along with one other person.
They are joint owners, my lords, husband and
Comma.
wife.
This court has already passed an interim order dated 29/1/2024, recording the contention of the petitioners that the allegation made in the notice earlier issued by the BBMP is incorrect, since the petitioners have only put up a temporary structure for protection of any material or articles falling from the higher floors on the residents of the ground floor or the first floor. Full stop. Learned counsel submits that the impugned notice has now been issued by the Bangalore Development Authority on the same allegations. Full stop. Therefore, the petitioners should be granted the same relief as is granted in the connected writ petition. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned
Notices from annexures A to L, my lords.
No, it has culminated in a final order.
That is addressed to the association, my lords.
Correct. Where is that?
My lords, that is found at
Annexure
annexure
P.
P, my lords.
ಏನಂತ? Of the final notice dated 2/5/2024 at annexure P and the notices issued to the petitioners at annexure A to
L, my lords.
L. Come on till the next date of hearing.
My lords, the connected matters interim order may kindly be extended, my lords.
It is not any conditional order. It is not till the next date of hearing.
Yes.
Grateful. Number 19, Veena TN.
Appearing for petitioners, my lords, filing memo for withdrawal, reserving liberty to file a comprehensive petition in
Why?
future. Some
Comprehensive petition.
as in fresh liberty to file a fresh petition in future in case any course of action arises.
Ian, what is that subsequent developments?
My lords, there's some confusion with respect to requirement of commencement certificate. So there's a representation that we have presented. Therefore, withdrawing this petition, my lord.
Learned counsel for the petitioner has filed a memo dated 28/5/2024 stating that having regard to the subsequent developments, the petitioner may be permitted to withdraw the petition and if necessary, file a comprehensive petition on the same cause of action. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn, reserving liberty as prayed for.
Sure.
Bill number 20, B N Prakash.
Appearing for petitioner, my lords.
This matter, my lord, there are some orders are challenged before the Honorable Supreme Court, my lord. There is a ground was taken before in this CMP that, my lord, after issuance of section 21 notice, my lord, seeking an appointment of arbitrator after lapse of 3 years, my lord, the section 11 petition is filed, my lord. That grounds was taken before this Honorable. The ground has been rejected. Whereby, my lord, they file an application under section 5 seeking condonation of delay to file this section 11 application. That application was allowed. My lord, challenging that orders, my lord, we approached the Honorable Apex Court, my lord. There's an interim order is granted, staying the, my lord, operation of that orders which, my lord, the delay was granted. My lord, in the last occasion before the Honorable Apex Court, my lord, on 27/2/2024, matter was listed and it was adjourned, my lord, on request of the petitioner, my lord, on 22/7/2024. The notice for appointment of arbitrator was issued on, my lord, 31/10/2012, Annexure D, page number 24. They approached, my lord, after 3 years, my lord, in the 2016, my lord, they filed this CMP petition. And ground of limitation was urged, my lord. They filed an application on section 5 seeking condonation of delay. And the delay was condoned, my lord.
That order has been stayed, is it?
That order has been stayed, my lord.
It stayed in the SLP, my lords. In fact,
The memo is also filed to that effect on
we have
13/10.
sought for a time in that matter in the SLP. It is stayed there.
Therefore, this matter
Yeah.
cannot go on.
Please, ma'am.
Yes, my lords.
If that order allowing the application for condonation of delay
Yes.
has been stayed by the
Yes.
Honorable Supreme Court,
Yes, my lords.
then the question of going on with the matter itself would not arise.
Yes, my lords. Very true.
We'll have to await the orders of.
Very true, my lords. In fact, they were making submission. That's the reason I was waiting for.
The, my lord, the date has been given, my lord, and the
It's on
Honorable Apex Court.
22nd of July.
22nd of July.
July, my lord,
July.
feet commencing 22nd July.
Since it is not disputed that the Honorable Supreme Court has adjourned the SLP filed at the hands of the respondent herein
Respond number 1.
to 22nd of July.
Week commencing 22nd July, my lord.
Tentatively, I believe, my lords.
To be listed
Week
in
commencing.
the week commencing from 22nd of July 2024.
Please, ma'am.
Comma, the matter will have to await further orders of the Honorable Supreme Court.
Please.
Full stop. Next para. Accordingly, the matter may be kept out of circulation. Full stop. Liberty is reserved to the learned counsels on both the sides to move a memo if any orders are passed by the Honorable Supreme Court.
Please, my lords.
Oblige.
Bill number 21, A Mahesh Chaudhary.
Matter is called out. There is no representation for either of the parties. Release this matter on 11th of June.
Bill number 22, Osmani Shakil Ahmad.
Same order.
Bill number 23, Dhananjay Joshi. H Pavitra.
My lords, I am for the respondent. My lord.
Matter is called out. There is no representation for the petitioner. Release this matter on 11th of June.
Much obliged.
24 adjourned. Serial number 25, Shyam V Prasad.
Please, my lord. Appearing for the petitioner, my lord.
Yes.
My lord, the arbitration clause is in partnership deed between the parties. My lord, here the petitioner and respondent number one are husband and wife. They're estranged. There's a divorce petition filed before the family court. My lord, on last day to, my lord, basically, my lord, the petitioner has retired from the partnership concern, and her dues has not been cleared. The claim is with respect to the dues. On last date of, my lord, on the request of the respondents only, my lord, the parties were sent for mediation if anything can be, but my lord, the mediation has failed, my lord. So, my lord, the respondents have not disputed that the dues are not cleared.
I appear for the respondent, and we are willing to pay the dues as per our balance sheets, but what they are claiming is.
Therefore,
Yes.
matter may be considered by the arbitrator. Let him
Yes.
consider.
Yes, please.
Perfect. The petitioner is whose wife?
Respondent number one's wife.
Who's respondent number two?
The brother of respondent.
Brother.
Yes.
Brother-in-law of petitioner.
Which is the contract?
My lord, at page number 19 of the petition, partnership deed, the clause is at page number 22, clause 14.
Partnership deed.
Please, ma'am.
The dispute arises out of a partnership between the parties who are members of the same family, in terms of a partnership deed dated 20th of June 2014. Full stop. Petitioner is the wife of respondent number one, and respondent number two is the brother of respondent number one. Full stop. The partnership deed contains an arbitration clause at paragraph number 14. Notice invoking the arbitration clause was issued by the petitioner on 6th of February 2023, and a reply was caused by the respondents on 22nd of February 2023. Full stop. On the previous occasion, next para, this court had referred the matter to the Bengaluru Mediation Center with the direction to the parties to appear before the center on 5/10/2023. Full stop. Both the learned counsels submit that the mediation failed. Full stop. Nevertheless, having regard to the admitted facts, this court is of the considered opinion that the requirements of Section 11 of the Arbitration and Conciliation Act have been complied, and therefore the dispute has to be resolved by an arbitrator. Full stop. Next para. Retired district judge is sufficient.
Yes, ma'am.
Next para. Consequently, the civil miscellaneous petition is allowed. Full stop. Sri Narendra Kumar Gunki, retired district judge, is appointed as the arbitrator to consider the disputes and claim arising out of the partnership deed dated so and so. So, I make paragraph format.
One submission, Your Lordship. They have withdrawn their claim for reinstatement. If that sentence also.
That's already there in the last order sheet, my lord.
The last but one para in the previous order sheet, dated 3/10/2023.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಪ್ಯಾರಾ ಮಾಡಿಕೊಂಡು learned counsel for the respondent has pointed out from the daily order dated 3/10/2023 recorded by this court that the petitioner has made a submission that she will not seek reinstatement as a partner, and the said submission was recorded by this court. Full stop. The learned arbitrator shall take note of the same.
Great.
Bill number 26, Krishna is last.
Appearing for the petitioner in this matter, my lords. Now, this is a case in which a tender notification came to be issued by the Department of Skill Development and Livelihood, my lords, then known as Directorate of Employment and Training, Kaushalya Bhavana. My lords, there is a arbitration clause which is contained at ink page number 107 at 27.2.1, my lords.
You have taken notice, is it?
Notice has been given, my lords. The opposite party is government, my lords.
Yes, yes.
Yes, sir. The arbitration clause is at ink page number 107.
Have you got instructions? Learned HCP, appearing on behalf of the respondents, seeks for a short accommodation to secure instructions and make submissions.
A date may be fixed.
Full stop. Next para. Release this matter on 11th of June.
33 is also the same matter, my lord, same contract. 33. They say that office objection is not complied with. There the objection is that, my lords, Directorate of Employment and Training anta mention agide tender alli. I have mentioned it as Department of Skill Development and Livelihood. Ivagiro ಹೆಸರು ಬಂದು Skill Development and Livelihood. That is only objection.
Office, serial number 33, office objection is overruled.
Yes, my lords.
Huh?
It may be connected with this matter and notice may be.
Next para, learned HCGP is directed to take notice for both the respondents.
Much obliged.
ಇಬ್ಬರೇ ತಾನೆ?
ಹೌದೌದು, ಇಬ್ಬರೇ respondent. I will serve the copy.
Good stop. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned HCGP. Full stop. List this matter along with WP, CMP number 381 of 2023.
Any date, my lords?
Are same. 11th of
11th.
June.
Much obliged.
Seal number 27, Sunil Kumar H.
Lord, the arbitration clause is at page 35, my lord.
My
It's a
lord,
dispute between the brothers. Second respondent is the elder brother.
I seek time to file objections, my lords. There are serious allegations of fraud.
That cannot be a reason, madam. Allegations of fraud means that then you will have to make that submissions before the arbitrator.
Arbitrator.
We are only concerned about appointment of an arbitrator. We are not going into the
Merits of.
merits of the case.
My
In
lord,
terms of section 11,
Please.
if a notice has been issued by the other party invoking the arbitration clause, calling upon you to come forward to agree or accept the proposal made by the petitioner of some name suggested for arbitration, for appointment as an arbitrator. And if you don't accept it, only then a CMP will be filed.
Yes.
If you had accepted it, you would have gone before the arbitrator by now.
that's what my lords, they want to, they want to undergo the trial, my lords.
So therefore, you go before the arbitrator then. We are only appointing an arbitrator, aste. Please take instruction.
I seek.
Huh?
May I have it pass over, my lord?
We'll have it day after tomorrow.
Please.
Okay, please, thank you.
At the request of
Great.
the learned counsel for the respondent, release this matter on 30th of May.
Please, please. Obliged.
Grateful.
Great.
Seal number 28, order passed. Seal number 29, Bala Nikit.
My lords, I appear for the petitioner, my lords. The joint development agreement, my lords, is at annexure A, my lords, page number 24. The arbitration clause is at clause 29, my lords, at in circle page number 68, my lords. Specific performance and dispute resolution. In accordance.
2011 JDA.
Yes, my lords, it's a 2011 JDA. Yes, my lords, it is a 2000. The dispute is between the land owner and the developer, my lords. The petitioner is the first party, who is the landowner, my lords. The respondent is the developer.
What was the time period for completion?
My lords, the time period for completion, I think, was 4 years or something, my lords. 1 second, my lords. Was the, sorry, my lords.
All right. We will see. Let them come before this court and point out.
Yes, my lords. In fact, my lords, they have themselves filed a section 9 petition before the trial court. And that petition, my lords, we have appeared. So the existence of the arbitration clause is not in dispute, my lords. They also admit that there is. The notice of arbitration is at page number 96, my lords, that we have issued to them.
They had issued a notice to you.
No, my lords, this is a notice issued by the petitioner, my lords. They had also issued a notice to which we have responded, my lords. In this, we have invoked the arbitration clause at paragraph number 3, my lords, at page number 97.
Issue notice to the respondents.
Obliged.
Seal number 30, Praveen Egde.
Lords, there are certain office objections. I shall do the needful during the course of the day. The matter could be taken up at the end of the list or by 2:30, please, my lord. challenge the order of demolition.
Yes.
My lord, one Mayana is my vendor. He is my cousin. His house and my house, the house of the petitioners, are adjacent to each other. Photographs, what I have produced, before my lords if my lords could appreciate annexure D, please, my lord. As per the office objections, I need to renumber it as D1, D2 in that form. He filed a writ for mandamus as his representations before the authorities were not considered, wherein his claim was that the house what I have constructed on the property and the dilapidated old house which was renovated by me falls within the purview of 40 meters as per the notification.
What
My lords,
notification?
Notification with regard to a claim that the road is a district highway, wherein I am supposed to construct leaving aside 40 meters distance. My lord, according to me, the same.
Who issued notice to you?
My lord, my vendor in title. He made representations. He filed a writ of mandamus before my lords, before this court. The writ of mandamus was issued to the authorities to consider the representations of one Mayana. Thereafter, my lords, a contempt petition came to be filed by the said petitioner before this court, wherein the authorities gave their statements, they would do the needful in accordance with law. Notice has come to be issued in annexure F, please, my lord. An undated notice has been issued by the second respondent, please. A direct and order of demolition has been passed. If the ink page number 31 be looked into, please, my lord, the second page of annexure F. There is no date specified in this particular notice. It is sent through a registered post.
No, but it has been recorded in the order of the Honorable Division Bench.
Please, my lord, as per the contempt petition.
Yes.
The division bench, the contempt petition was with regard to a writ of mandamus, wherein the representations of the petitioner, namely Mayana, was not considered. Citing the case numbers in terms of the contempt petition, this notice has been issued, please, my lord, seeking to demolish a dwelling house. If my lords could appreciate page number 37, please, my lord. Notification of the state in
Yes, it has been recorded that notice has already been issued to you. That is the notice that you are now challenging.
no, please. As per the contempt petition, please, my lord.
Yes.
It is. This is not the notice. This is not the notice. This notice has reached me on 16th of this month, please, my lord. 16th May. Subsequent to the contempt proceedings, if my lords could appreciate annexure F, ink page number 30, please, my lord. There is a reference made in terms of the contempt petition. Ullekha anta bardidaru Swami, subject Vishaya admele Ullekha. There is a reference with regard to contempt.
Page number?
Page number 30, please, my lord. Ink page number 30.
Yes.
Vishaya Ullekha anta hakidare. This particular order is subsequent to the contempt petition, please, my lord. A straightforward order of demolition has been ordered with regard to a dwelling house. This is my only dwelling house, please. My specific contention is that When I purchased the property, there was an old house. I have reconstructed or renovated it. Aspect number 2, the contention of the petitioner during the proceedings before this court in terms of mandamus, that I have deviated the notification of the state dated 36/2022. As per ink page number 36, please, my lord. If the next page be looked into, page number 37, ರಾಜ್ಯ ಹೆದ್ದಾರಿಯ ದಾಖಲಿತ ರಸ್ತೆ ಭೂಗಡಿ ಅಂಚಿನಿಂದ ಕಟ್ಟಡ ರೇಖೆ ಅಂತರ.
ಆಯ್ತು, ಬರ್ಕೊಳ್ಳಿ. Learned AGA takes notice for response number 1 and 2. Issue notice to response number 3 and 4. The petitioner is also permitted to serve a copy of the writ petition along with annexures on learned counsel Sri D.J. Somyaji, who appeared for respondents number 3 and 4 before the Honorable Division Bench in CCC number 607 of 2023. Full stop. And a copy on the learned AGA. Full stop. Next para. Learned counsel for the petitioners submits that although it is not disputed that a statement has been recorded by the Honorable Division Bench during the content proceedings that the Assistant Executive Engineer who was present before the court stated that the directions will be complied within 12 weeks and that a notice is already issued to the petitioner. Nevertheless, the petitioner did not receive any notice, had not received any notice at that point of time.
Till date, please, my lord, apart from annexure F.
The petitioner has only received the impugned notice at annexure F, which has no date on it.
Through register post, I have received on 16th of May.
But it is not disputed that the petitioner received the impugned notice at annexure F on
16th May 2024.
16th of May 2024 through registered post.
Yes, please.
Full stop. Learned counsel submits that a plain reading of the notice clearly shows that no opportunity of hearing was given to the petitioner and the impugned notice is only calling upon the petitioner to remove the alleged encroachments within 1 week from the date of receipt of the notice. Please. Full stop. Learned counsel therefore submits that if the impugned order notice is not stayed, the second respondent will proceed to demolish the building without even affording an opportunity of hearing to the petitioner and in violation of the principles of natural justice. Full stop. Moreover, it is submitted that the complainant, Sri R. Mayanna himself, had sold the property in favor of the petitioner. And the petitioners have only taken up a reconstruction on the same land where the said Sri Mayanna, the vendor of the petitioners, had earlier put up a construction.
Please, below.
Full stop. Next para. Consequently, there shall be an ad interim order of stay of all further proceedings pursuant to the impugned notice at annexure F till the next date of hearing. Please. Full stop. Next para. In the meanwhile, office objections shall be complied with. I shall do.
Order. Serial number 31, order passed. Serial number 32, Manmohan PN.
Kindly grant 2 weeks time, my lord. We'll file necessary application.
What?
I'm appealing.
Huh?
We'll file application, my lord. Some respondents are passed away. 4 respondents, my lord.
At the request of learned counsel for the petitioner, 2 weeks time is granted to take necessary steps in respect of deceased respondents number 15, 24, 28, and 29.
Please.
Serial number 33, order passed. Serial number 34, Manmohan PN.
My lord, 1 week time may be granted, my lord. We'll take fresh step. We'll take
A
steps.
week's time is granted at the request of learned counsel for petitioner to take fresh steps.
Please.
For service of notice on respond number 4.
Serial number 35, KV Narasimhan.
I appear for the petitioner. And, my writ petition, my lord, is filed, seeking the writ in the nature of mandamus. In view of the fact, my lord, my neighbor, without taking the sanction plan, my lord, wanted to put up construction. The connected petition arises out of the order, by the virtue of which, my lord, the application filed by the respondent in my case has been rejected. The sanction plan has not been issued. That is challenged in the connected writ petition. And that is how, my lord, 2 matters, my lord, have come up.
You are the complainant.
I'm the complainant. My lord, I am aggrieved by the fact that, my lord, respondent number 5 in my writ petition is putting up construction without leaving setback towards my property and also without obtaining the sanction plan. The construction, my lord, was commenced, and hence, my lord, I filed a complaint. It was not considered, and hence, my lord, I filed the writ. The connected writ petition, my lord.
Any interim orders have been passed?
My lord, in my writ petition, interim order, my lord, staying further construction has been passed. Because evidently there is no sanction plan.
Our writ petition, no? That was subsequently filed.
Subsequently, it was filed, challenging the endorsement by the virtue of which, my lord, the application seeking sanction of the plan was rejected by the BBMP.
Why was it rejected?
My lord, it is said, my lord, that the sites have not been released in favor of the Urban Development Authority, and the Katas, my lord, have not been entered into. As such, there is no provision for sanction of a plan.
But appearing for respondent in first matter, connected matter, petitioner matter.
Non-amendment of WP. ಯಾವ್ದು ಅದು ನಿಮ್ಮ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
Please.
ಏನದು? What amendment? ನೋಡ್ರಿ ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನು ಇಲ್ವಾ ಅದರಲ್ಲಿ? Twenty-one to 2024. Carry out corrections in prayer A and in the interim prayer column. ಏನ್ರಿ ಅದು?
Kindly pass, sir.
What was that?
I'm not sure. My
Prayer A.
I'm not a party, my lord. I have not been arraigned as party in this writ petition.
No. These orders are passed
commonly, but my lord,
commonly.
Since, my lord, only the rejection of the sanction plan, my lord, is in challenge in that petition. I have not been arraigned as party, and I am not aware.
Don't have a copy of the
I don't have the copy of the writ.
What is it? Annexure G nenadu. Quash the endorsement dated 5/8/2023 issued by respondent number 2. Annexure G.
Annexure G, my lord.
Correction ಆಗಿದೆಯಲ್ಲ.
Annexure G, correction. Carried out. Action is carried out. Instead of G.
ಮುಂಚೆ ಏನ್ ಬರ್ದಿದ್ರಿ?
H ಬರ್ದಿದ್ವಿ.
H.
G ಮಾಡಿದ್ವಿ.
Learned Counsel for in WP number 4703 of 2024. Learned Counsel for the petitioner submits that the correction has been carried out in prayer A, in terms of the directions issued by this court on 21/2/2024, showing the impugned endorsement dated 5/8/2023 as Annexure G.
Please.
Full stop. ಆಮೇಲೆ
BBMP will have to respond, my lord, to his writ petition first. If at all he can get the sanction plan, my lord, then the point of proceeding with the construction would arise.
It's a private layout, is it?
Yes.
Already
Private
it's a layout, please. Private layout.
But they had obtained a sanction plan.
No, sanction plan is
For formation of the layout.
for the
That is why
formation
the
of
question of releasing the
Please.
sites would come.
please,
Otherwise, there is no question of releasing the
releasing
sites.
the site, please.
ಎಲ್ಲಿದೆ ಇದು? Which is this place?
This is, my lord, in Rajeshwari.
Rajarajeshwari.
Gruha Nirmana Sahakara Sangh. That had formed the layout.
How is it that you took up construction without even obtaining a sanction plan?
No, my lord. The site is released. I have the order.
Where is the sanction plan?
Senior is held up. Kindly pass on. The last day.
At the request, next para, at the request of learned counsel for the petitioner in WP number 4703 of 2024. Release this matter on 4th of June.
Please. Interim order.
Interim order granted earlier,
Not to put up further construction is granted in my writ petition.
interim order granted earlier in WP number
2-3.
23281 of 2023 is extended till the next date of hearing.
Great.
Serial number 36, Shailesh S. Katari.
I appear for the petitioner. In this case, petitioner is a cooperative bank. The fourth respondent availed a loan which he failed to pay. Thereafter, I brought his property which was secured towards repayment of the loan, and that property has been ultimately sold in favor of the fifth respondent on 15th May 2023. My lord, your lordship.
Although it was mortgaged to you.
Mortgaged to me. It was mortgaged to me, and since he defaulted in repayment of the loan, I brought the property for sale, and property has already been sold, and sale certificate is also issued on 15th of May 2023. Then the fifth respondent, who is a purchaser, he has asked for delivery of vacant possession, but the third respondent has said that he has no powers to give vacant physical possession of the property.
Fifth respondent is?
Fifth respondent is the assistant registrar of cooperative.
No. Who is fifth respondent?
Fifth respondent is the purchaser.
Purchaser in the auction or?
Auction.
Auction purchaser.
Auction purchaser. He has purchased the property paying about 1.5 crores. Now he asked for vacant possession of the property. So I made a representation to the third respondent to give vacant possession of the property, which he has failed to do. Though he has legally, he says there is no legal provision under the KCS Act to give possession of the property. But having regard to Rule 38A(5), there is a provision which enables the assistant registrar to give possession of the property to. Please see Rule 38 capital A 8B. I have culled out that portion. Rule 38 capital A 8B. May I read, my lord? The transfer of the property under sub-rule 5 shall be effected as follows. B, where the property is in possession of the defaulter.
One nimsha.
My lord.
38.
Rule 38, capital A, capital A.
38A ಅಂತಿದ್ಯಾ?
ಹೌದು. Rule 38, capital A, 8B.
38A
8B.
The transfer of property under sub-rule 5
shall be effected as follows. B, please come to B. Where the property is in possession of the defaulter or of some person on his behalf or some person claiming under a title created by the defaulter subsequent to the issue of certificate under section 101, the court or the deputy commissioner or the registrar, as the case may be, shall order delivery to be made by putting the society or any person whom the society may appoint to receive delivery on its behalf in actual possession of the property, and if need be, by removing any person who illegally refuses to vacate the same.
Yes. You are appearing for?
Fifth respondent.
Fifth respondent.
For action purchase.
Who is appearing for this fourth respondent?
Fourth respondent, I have taken out hand summons. He has refused to take it. I have filed an affidavit also to that effect. And I also taken process on 2 occasions, my lord. He has refused to appear before this honorable court.
Allah, what happened to the court notice?
My lord,
the court notice.
Court notice, my lord, I have taken process. He has, on the first occasion, he has not come. Subsequently, fresh notice has also been issued. He has not chosen to appear, my lord. On 3rd April also I have taken notice. I have taken process, my lord.
Adinu return agilva?
I think it has returned.
ಬಂದಿದೆ ನೋಡ್ರಿ ಪೋಸ್ಟಲ್ ಇದು ಶರಾಬ್ ಬಂದಿದೆ ನೋಡಿ ಅನ್ಕ್ಲೈಮ್ಡ್ ಇಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 emergent notice issued to respond number 4 ಕೊಡೋದಿಲ್ಲ ಏನು ಅಂತ ತಿಳ್ಕೊಬೇಕು. unserved. Cover returned with postal shara unclaimed. Ilva.
ಅವರು ಮಾಡ್ತಿದ್ದಾರೆ ನಾವು ಕಡಿಮೆ ಪರ್ಸೆಂಟ್ ಅಮೌಂಟ್ ಕೊಡ್ಬೇಕು.
ಒಂದು ರಿಟರ್ನ್ ಆಗಿಲ್ವಾ? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4. ಬರ್ಕೊಳ್ಳಿ. Although there was a specific direction given by this court on the previous date of hearing, that is 23/4/2024, that the office shall put up a report regarding notice issued to respond number 4 through court. And in the office note, it is stated that emergent notice issued to respond number 4 has returned unserved with a postal shara, inverted commas, unclaimed, comma, nevertheless, comma, on verification, comma, it is found that emergent notice issued to respond number 5 has returned and not the notice issued to respond number 4. Full stop. However, with regard to the hand summons permitted to be taken out to respond number 4, by order dated 27/3/2024. Comma, the petitioner the senior assistant of the petitioner bank, Shri Vijaya Sai G, son of Gangaya, has filed an affidavit dated 3/4/2024, stating that the 4th respondent has declined to receive the hand summons. Full stop. Next para. Consequently, the notice taken out on respondent number 4 is held sufficient. Full stop. Next para. Learned counsel for the petitioner has drawn the attention of this court to clause B of subsection 8, subrule 8 of rule 38 capital A, and submits that this court is empowered to direct the deputy commissioner or the registrar of cooperative societies or the competent authority to take delivery of the secured immovable property from the defaulter or any other person who is in possession of the property on behalf of the defaulter or some person claiming under a title created by the defaulter subsequent to the issue of certificate under section 101 of the Karnataka Cooperative Societies Act. So, next para. The third respondent, Assistant Registrar of Cooperative Societies and Recovery Officer, is therefore directed to take possession of the scheduled property bearing number 37/2, Kata number 319, Mallathalli village, Yeshwanthpura, Bangalore. And hand over possession to the fifth respondent, who is the successful auction purchaser at the hands of the petitioner Cooperative Bank. And the third respondent shall submit a report before this court on the next date of hearing. Please stop. Release this matter on 11th of June. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಆಡ್ ಮಾಡ್ಬಿಡಿ. The learned counsel would therefore submit that the dates and events mentioned in the writ petition clearly shows that the auction in favor of the fifth respondent was conducted on
Sale certificate is issued on 15th.
Auction was conducted on 2/3. 2023.
Yes.
And a sale certificate was issued in favor of the fifth respondent on
15th May 2023.
15th of May 2023. Full stop. Whereas the fourth respondent seems to have executed a sale deed, Fourth respondent.
Fourth respondent has not executed any, he has executed a DTD in the favor of the bank.
ಅಲ್ರಿ ಅದ್ ಯಾರಿಗೋ ಇನ್ನೊಬ್ರಿಗೆ ಮಾರಾಟ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Allah, he has not sold, he is in possession of the property.
He himself
Himself is in
defaulter.
Defaulter is in possession. Defaulter is in possession.
Then what is the difficulty?
No, the difficulty is the defaulter is refusing to vacate the property and the assistant registrar has refused to hand over vacant possession to me.
No, you made a submission that he has sold it to someone else.
No, he has not sold it, my lord. He is in possession.
He
of
is
the
in
property.
Right. Yes.
Number 37, Vivekananda TP.
That's what number 329.
But on the previous date of hearing minutes, the Zonal Court, while hearing the application for direction filed by the petitioners, has passed an interim order directing the Mysore City Corporation to file a report, not answering the points raised in the orders passed by the Zonal Court. Kindly see the last.
Lord, I pray for some time, my lord, in
22nd.
view of the elections, they could not carry out the instructions, the directions of the Honorable Court, my lord.
This order was passed on 22nd April 2024 minutes. And my lord, in spite of the interim order passed by this honorable court, the private respondents are my lord, proceeding with the construction merrily. And even now, my lord, the construction is going on. My lord, they don't have any respect to the court orders. My lord, even Mysore City Corporation is my lord, closing their eyes and my lord, they are supporting the private respondents to construct the building.
My lord, this is in a revenue belt. That layout has not been handed over to us. And we have no control over this authority or this layout, my lord. As per the government instructions, my lord, the notifications in such areas, it's the deputy commissioner who has to.
That may be correct. But if a specific order has been passed by this court.
We'll conduct a survey and place it on record, my lord. For that I request for time, my lord. That's an oversight by our corporation officers. We should have done it. When I inquired with them, they had some difficulty, my lord. I pray for 2 weeks' time, my lord, it will be placed on record. The directions of this honorable court will be complied with. Now, the second query which the counsel for the petitioner mentioned, that we have not taken steps. We had issued notice, but it has been recalled because the government directions are that the DC has to take steps, my lord. It's now the deputy commissioner who has to take steps. That those notifications are there, I'll place it by way of objections, my lord. In fact, it's ready, but some oversight on my side, my lord, that I have not filed it. I will file that also, my lord. The deputy commissioner has to do this, my lord. In previous years, your lordship also has passed an order.
The earlier interim order is dated 13th of February 2024. My complaint in the application is that I have produced the photographs in respect of the structures which were standing as on the date of interim order. This honorable court, while granting interim order, directed me to produce the photographs showing the status of the construction. Thereafter, since the construction was continued in spite of the interim order, then I filed an application bringing on record the latest photographs showing that construction is still going on. Even yesterday, I have received photographs from the petitioners. Even as on date construction is going on. Till such time the matters are decided. Is it not the duty of the corporation to make the private parties to stop construction? Or else the private parties who are before this honorable court to respect the court orders at least.
What is the dispute?
It is an agriculture land, my lords. It's an agriculture land. There was a proceedings under the Urban Land Ceiling Act. The petitioner's father and his uncle, they filed a suit for declaration of title and declaring that the proceedings are lapsed. That suit is decreed. The state has filed an appeal before the district court. The appeals are pending. There are no interim orders. The status of the land is agriculture. in an agricultural land, these private parties are putting up, they claim that they have purchased through a sale deed, which are not registered under, which is drawn in a 5 rupees stamp paper, and they claim that we are the owners of these sites. There is no demarcation. It is an agriculture land. There are no roads, no amenities are provided, no conversion order is passed by the deputy commissioner. Our grievance, our prayer is, since the matter is seized before the civil court in respect of a proceedings under Urban Land Ceiling Act, if we succeed, we will not be in a position to protect our property, vacant agriculture land. By that time, if these people will construct the buildings in an agriculture land. On an earlier occasion, there was a writ petition before your lordship, filed by my uncle and his son, where he has sought for direction to the deputy commissioner and the tahsildar to protect the land till such time the matters are decided by the civil court. Before this honorable court, the tahsildar has filed an affidavit stating that we are protecting the land and we will protect the land. Taking note of that submission, lordships have decided, disposed of that matter. On one hand, Mysore City Corporation says this is not within our jurisdiction. On the other hand, now they are passing the bucks on the revenue authorities, and revenue authorities are not visiting the property on the pretext that the property is in the within the jurisdiction of Mysore City Corporation. There are many lands which are within the municipal areas. That doesn't mean that only the deputy commissioner will have to take action. If the lands are within the municipal area, it is the duty and responsibilities of the municipal corporation to see that no constructions are put up in an agriculture land without license, without conversion order. If somebody is constructing, the corporation cannot keep quiet, saying that no, it is an agriculture land, therefore we can't go there.
These private respondents are not party to the proceedings in the suit.
They are not parties. In fact, the petitioner.
They're parties.
They are
sir.
parties.
They're parties.
I am a party in that suit.
I'm sorry.
They are parties.
No,
And they have failed to
One
obtain
second.
the temporary injunction.
The suit is between the government and the private parties. In that suit, the decree is granted in our favor. The state is in appeal.
There are no private
In
respondents.
that proceedings, there are no private respondents. There is one more suit in which my uncle has filed a suit against these private respondents for injunction. There is an order of injunction there also, not to put up construction. They don't care the orders of the civil court, and they don't care for the interim order granted by this honorable court. And in spite of there being a direction to the Mysore City Corporation to go and visit how many constructions are going on, how many constructions are completed, and how many licenses are issued. Now, even after 1.5 months, the Mysore City Corporation has never visited the land, property. Yesterday, construction is going on. And my only concern is, till such time the cases are decided, let them hold their hands and keep the property as an agriculture land.
Lord, my
Whom-
submission, my lord, my submission is, my lord, I have not put up any constructions, my lord. I'm already residing in that land in question, my lord. I'm not been putting any constructions. Now-
How did you acquire rights over the property?
My lord, they have sold the property to me.
Who?
The petitioners, the father and uncle of the petitioner sold the property to me. And I have been residing that property by putting up of the construction. My construction is already completed. It has not been started. Now, my lord, they have put up false photos where I have not been putting up of the
You have filed
construction.
a statement of objection?
Yes, my lord.
You have stated, you have furnished a copy
Please,
of
my
the sale deeds?
Copy of the sales have not punished, my lord, but still
No,
the matter is pending.
Right.
I may claim adverse position, my lord. Even in the matter pending before the.
What is this? What are you saying?
My lord,
You said they have sold the property to
yes,
you.
I have sold the property.
And when I'm asking you whether you have furnished a copy of the sale deed,
I have produced, my lord. I have produced.
please show it.
Okay.
No sale deeds are produced, along with
Sale
the
deeds I have not produced, my lord, but there is a compromise decree executed by them. I have produced the compromise before the Lok Adalat. 35, my lord, page number 35. Compromise, there was a compromise decree between me and the petitioners, my lord. And that compromise decree I have produced before your lordship, my lord. Page number 35. During the pendency of the suit, my lord, the matter was referred to the Lok Adalat. In the Lok Adalat, a compromise decree was, a compromise happened, my lord. There was a compromise between me and the petitioner.
Page number?
Page number 35.
35.
Annexed R3. According to the according to the compromise decree, my lord, they have executed the sale deeds. Now, as per the compromise deed, my lord, I have been staying in the land. Now, my lord, in order to just demolish my construction that I have already be put up, they have filed this writ petition. The matter is pending and they have failed to obtain temporary injunction before the trial court. And they have also preferred MFA against the temporary injunction. Even before the MFA, they have not obtained any temporary order. Now they have filed this writ petition, my lord.
Where is that compromise?
My lord, I have engaged senior counsel. Maybe 2 days time may be granted. He is engaged in other. Okay.
ಅದಕ್ಕೆ senior
ದಾವೆಯನ್ನು ವಾದಿಯು ತಾರೀಕು 10/5/1980 ನೋಂದಾಯಿಸಲ್ಪಟ್ಟ ಕ್ರಯದ ಕರಾರಿನ ಆಧಾರದಲ್ಲಿ ಪ್ರತಿವಾದಿಗಳು ಕ್ರಯಪತ್ರ ಬರೆದುಕೊಟ್ಟು ನೋಂದಣಿ ಮಾಡಿಕೊಡಬೇಕೆಂದು ನಿರ್ದಿಷ್ಟ ಪರಿಹಾರ ಹಾಕಿರುತ್ತಾರೆ. ನಂತರ ಉಭಯ ಪಕ್ಷಕಾರರು ಹಿತದೃಷ್ಟಿಯಿಂದ ಮತ್ತು ಪಂಚಾಯಿತಿಯವರ ಸಲಹೆ ಮೇರೆಗೆ ಜನತಾ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅವರೊಳಗಿದ್ದ ತಕರಾರನ್ನು ಇತ್ಯರ್ಥಪಡಿಸಿಕೊಳ್ಳುತ್ತಾರೆ.
You were the plaintiff, is it?
Please, my lord, I was the defendant in that case. I was the defendant, number 2. I was the defendant number 2 in that case.
Who is the plaintiff?
My lord, plaintiff is Nirmala. That is the
She is
wife
not
of
a party
Nagendra.
here, Lord. She is not a party
That
to
is the
this.
wife of Nagendra, wife of the contesting respondent. I mean, contesting respondent in other suit, my lord. That is, they are the relatives.
That plaintiff in OS 296 is not a party to this present proceedings, my lord. It is not concerned to this matter. She is not a.
Means you both are related.
No, my lords, we are not.
They are not related.
He is saying he is defendant number 2 here.
Please, my lord. Yes, Chelvegowda.
That's my client, my lord, name, my lord, is Chelvegowda. He is not representing, my lord, is Chelvegowda.
Sorry.
But if he is a defendant in that suit, my lord, he can't claim that there is a decree in his favor.
Daughter of S. Chelvegowda.
Alala, I'm sorry, my lord. I'm T. Chelvegowda.
Nirmal.
I'm T. Chelvegowda.
T. Chelvegowda. You are not a party to the.
My lord, I'm not a.
In this petition, my lord, the case Nirmala is not a party.
I need some.
ಏನು ಹೇಳ್ತಾ ಇದ್ದೀರಿ ನೀವು?
ಅಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ I need some instructions. I need some instructions. I'll come back, my lord. Therefore, anyway, my lord, the report is pending, my lord. Let them file the report, my lord. I need some instructions. I'll come back to your lordship, my lord, please. Let them file report, my lord. I have engaged senior counsel.
But if
Senior
according
counsel
to
will come and argue the matter.
according to the private parties, they have constructed the building and they are residing, my lord, they can't oppose, my lord, this petition. Wherein, my lord, I have sought for direction to the
Yes.
persons, my lord, who are putting
My
up
lord,
construction.
my lord,
It is because of this submission only, on the last occasion, lordships have directed that let the corporation file a report. Who are the persons who are constructing the building? How many licenses are granted? After, my lord, submission of the report, the lordship can, my lord, decide the matter. It is in that circumstance, because of this kind of submission, this honorable court passed the, my lord, the previous order.
These respondents have not been putting up any constructions, my lord. Someone else have constructed and they have not been made as a party in this writ petition.
Sir, if you have put up construction, I am asking you on what strength have you put up the construction? How are you claiming that you are the owner of the property?
I'll produce more. I'll engage senior counsel.
You have filed a statement of objection already and you are not able to say anything.
2 days, I thought that report is.
And you want to oppose the submission of the learned counsel.
Report is pending. I'll come back. I'll definitely come back and I'll submit before your lordship.
You take law into your hands and start making submissions before this court.
Sorry, madam.
Yes, Mr. Ravi. What is the basis of your claim? What is the strength on which you have put up construction on this property?
My lord, there are agreements in favor of these respondents in question by the owner. That
Who
is
is the owner?
father and uncle of the present petitioner. And suits were filed. In the suits, my lord, the matter was referred to the Lokadala. Therein, my lord, the father and uncle of the petition herein agreed to deliver the possession. I have been in possession by strength of the compromise
That is what
decree.
the learned counsel on record was pointing out this
Yes, my lord.
annexure
Yes,
R3,
ಅಲ್ಲಿ
which is
it's
the
a deliver-
compromise petition.
Yes, my lord.
Where is
So-
your name in this cause title? You are T. Chelvu Narayana, Chelva, you know?
ಚೆಲುವೇಗೌಡ
Chelvegowda.
ಹೌದು ಹೌದು
Your name is not found in the cause title.
ಇದೆ 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 ಇದೆ. ಅಲ್ಲ ಅದನ್ನ ನಾನು ಹಾಕಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. Last can you have day after tomorrow Monday? There are the records are there to show that we are in possession.
Sir, you have filed a statement of objection. You are pointing out to this annexure R3, which should be the basis of your claim. This is the compromise petition, but your name is not found in the cause title. ಯಾವ್ದೋ ಒಂದು ಸುಮ್ ತಂದು ಹಾಕ್ಬಿಡೋದಾ?
ಅಲ್ಲ ಲಕ್ಷ್ಮಿ ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ 40 ಮೇಲೆ ಒಂದು ನಿಮಿಷ. ಒಂದು ಎರಡು ಮೂರು ಮ್ಯಾಟರ್ ಒಂದೇ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಇರೋದು. ಒಂದು ನಿಮಿಷ ಬೈ ಮಿಸ್ಟೇಕ್ ಅದು ಹಾಕಿಲ್ಲ.
Yes, madam. If this kind of a order is recorded and directions are issued to the corporation, the least that you should have done is
Take note of it.
to have submitted a report. This kind of an attitude on the basis on the part of the officers of the corporation,
I have.
we cannot be
informed them, next, in a week or 10 days, we'll place it on record.
by next Tuesday. If you don't file a report, we'll have to take stringent action on the concerned officers. Berkeley. Learned counsel for the petitioner, while drawing the attention of this court to the previous order dated 22/4/2024, submits that despite a specific direction given by this court to the zonal commissioner, Mysore City Corporation, that he should visit the land seat survey number 155/1 and 159/1 of Hebbal village, Mysore Taluk, and file a report regarding specific instructions at serial number A to D, no report has been filed by the zonal commissioner. Full stop. Next para. Learned counsel appearing for the Mysore City Corporation seeks for a short accommodation to ensure compliance of the orders passed by this court. Full stop. Release this matter on 4th of June 2024.
ಅಲ್ಲ 4th ಬೇಡಿ ಲಕ್ಷ್ಮಿ ಆಫ್ಟರ್ 6th ಮೇಲೆ and ಸ್ವಲ್ಪ I will not be in station 4th and 5th.
ಅಲ್ಲ ಅವ್ರು ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡೋದಕ್ಕೆ.
ಅಲ್ಲ
Let them submit a report, then we will consider.
ಅಲ್ಲ at least
4th of June 2024.
5th ಮೇಲೆ ಸಪೋಸ್ ಏನಾದ್ರು
ಆಯ್ತು 5th of June 2024.
ಲಕ್ಷ್ಮಿ ಕೈ ಸಾರಿ ಮೇಲೆ ಪೇಜ್ 40 ಮೇಲೆ ಪೇಜ್ 40.
If a report is not filed by the zonal commissioner, the zonal commissioner, Mysore City Corporation shall himself be present before this court on the next date of hearing. Yes.
ಚೆಲುವೇಗೌಡ my lord, at page 40 my lord, instead of there is a amendment, T. ಚೆಲುವೇಗೌಡ my lord.
No.
Page 40.
We will consider.
Annexure R4.
Yes.
Number 38, Ajay Prabhu M.
In terms of the objection, I have paid process in morning, Lordship. I'm certain, my Lordship, last occasion, this Honorable Court has granted me the liberty to file, my Lordship, interim application for stay.
You know?
Last occasion, this Honorable Court has granted me liberty to seek for interim orders.
Non-furnishing of process stay.
ಹೌದು ಅದು ಕಟ್ಟಿದ್ದೇನೆ ಸರ್. ಅದು ಕಟ್ಟಿದ್ದೀನಿ
ಯಾವಾಗ?
ಇವತ್ತು ಬೆಳಿಗ್ಗೆ.
Learned counsel for the petitioner submits that the steps have been taken for service of notice on respondent number 5 this morning.
Yes, ma'am.
Yes.
And this Honorable last occasion has granted me liberty
Huh.
seek for interim orders.
ಇವತ್ತು steps ಇವತ್ತು ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ, first time ತಗೊಂಡಿದ್ದೆ, but has returned.
ಹಾ,
So I've taken again.
ಆಯ್ತು. They have already passed orders. You are appearing for the BBMP. They have already taken steps.
But last occasion submission was made that approval has not been taken.
ಅದೇ ರೀ, they were only awaiting approval
Yes, ma'am.
for proceeding further.
For Yes, ma'am.
demolition. Orders for demolition have already been passed.
ಇಲ್ಲ, orders signature ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳಿ approval ಆಗಿಲ್ಲ ಅಂತ.
ಏನಾಗಿದೆ ಇವಾಗ?
Lord, I've just filed the wakalat recently, my lord, and initially it was handed over to one Mr. Pawan Kumar. ಆದ ನಂತರ ನಾನು ಬಂದಿರೋದು, ರೀಸೆಂಟ್ ಆಗಿ ಬಂದಿರೋದು. So I will just seek instructions.
Next para. The Learned Counsel, next para, Learned Counsel Sri K.S. Mallikarjun Reddy, appearing on behalf of the respondent BBMP, submits that he would secure necessary instructions regarding the further orders that were awaited for demolition of the building
in question,
having regard to orders passed under section 356 of the BBMP Act, which was recorded earlier by this court. Full stop. Next para. Release this matter on 4th of June to enable the Learned Counsel for the respondent BBMP to secure instructions and make submission.
5th ಆಗ್ಬೋದು.
Huh?
5th.
5th. Next para. Since Learned Counsel Sri K.S. Mallikarjuna Reddy is appearing for the BBMP, the name of Learned Counsel Sri Pawan Kumar may be removed from the cause list. Please, yes. Please.
Case number 39, Satish Chandra R.
And for the
appearing for a petitioners, the office objections earlier has complied. One objection is again raised to file. I have to file a better copy of annexure A. My lords, I will do it during the course of the day, my lord. My prayer is that respondent number 5 and 6 is my neighbor. He has obtained the sanction plan, but now he is constructing by deviating the sanction plan. And the BBMP has inspected the leased under construction and issued a notice under section 248 and as per the annexure.
Respond 1 to 4, my lordship.
BBMP.
Yes, my lordship.
BBMP.
Yes, my lordship.
1 to 4 is the
Now
BBMP.
I received wakalat, my lordship. I have to yet to file wakalat, my lordship.
Learned Counsel Sri
Battagowda KV, my lordship.
Pattegowda
KV, my lordship.
KV undertakes to file wakalat for response number
1 to 4, my
1
lordship.
to 4, BBMP.
Yes, my lordship.
And for R5 and 6. Full stop. Learned Counsel Sri MD Raghunath. MD. D for MD Raghunath. Wakalat hakidira. Undertakes to file wakalat for response number.
I have filed KVI. He has filed the caveat. I have served it, my lords.
Caveat
is not. He'll put up
Submits
again.
that although he had filed a caveat petition on behalf of response number 5 and 6, his name is not reflected in the cause list. Full stop. The Learned Counsel, however, submits that he has received copy of the writ petition along with annexures from the petitioner.
File objection. No, my lord.
Objection illala file ಮಾಡೋದು. Our notice ಗೆ objection file ಮಾಡಿ. You should have convinced them that no, I have not deviated from the sanction plan.
My lord, wait. I have challenged that order.
They filed appeal, my lordship.
The commissioner.
They have filed appeal, my lordship, before the chief commissioner, my lordship. They have which is pending, my lordship.
It's pending.
Yes, my lordship.
There is a status for.
Which is pending, my lordship.
But he is not notified.
No, my lord.
The complainant.
No, earlier they
He has
have
not been notified.
No, earlier the ground floor owner has filed the complaint, my lordship.
Hello?
Ground floor owner has filed the complaint, my lordship. He's a first floor owner, my lordship.
On the basis of the other complaint, that action has been taken.
Yes, my lordship.
No, my lords, my submission is that.
You have got a copy of the writ petition?
I got it, my lords.
My lords, one submission.
Learned counsel for the respondent BBMP submits on instructions that earlier a complaint was lodged by another resident of the same building
Same building.
Mr. Kumara Vyasa.
against respondents number 5 and 6,
Yes, my lords.
but respondents number 5 and 6 have approached the chief commissioner
Yes, my lords.
by filing an appeal, and an order of stay has been passed by the chief commissioner, and the matter is pending consideration before the chief commissioner. Full stop. Next para. Release this matter
My lords, one sub.
on 18th of June 2024 to enable the learned counsel for the respondent BBMP to submit the further action taken by the chief commissioner.
Yes, my lords.
My lord.
Post 18th, the reason is, I'm given to understand the matter before chief commissioner is on.
18th,
Yes, my lords.
on 20th of June.
My lords, one submission, my lords. Kindly annexure the respondent 5 and 6.
Action ತಗೊಂಡಿದ್ದಾರೆ. They are before the chief commissioner. Let us see.
But they have, the respondent number 5 has obtained the injunction order before the city civil court, and they have approached the commissioner also.
ಆಯ್ತು. We are not concerned with the orders that will be passed by the civil court, because civil court will not have no jurisdiction.
Please, man, that's what.
Matter of violation of a
Please.
sanction plan.
Please.
It is appropriately before the chief commissioner.
Please.
Let him consider.
Please.
Yes.
Bill number 40, Rajeshwara PM.
For the petitioner, my lords. Respondents 4 to 6 is BBMP, my lords. I may be permitted to take notice on the BBMP advocate, my lords. And respondent number 7 is the
Counsel Shri Pawan
BWSSB.
is requested to take notice for respondents number
4 to 6.
4 to 6.
7 is BWSSB, my lords. I may be permitted to take notice on Mr. BL Sanjeev, my lords.
Full stop. Learned counsel Shri BL Sanjeev is requested to take notice for
Respondent number 7.
respondent number 7.
Private
Learned
parties,
counsel for
my lords.
petitioner is directed to serve copies of the petition along with annexures on learned counsel Shri Pawan Kumar and learned counsel Shri BL Sanjeev.
Please, my lords.
ಅದ್ ಬಿಟ್ರೆ
Private parties ಗೆ await notice ಇದೆ ಸ್ವಾಮಿ, ಅದು ಬರಬೇಕು.
full stop. List this matter up to service of notice on the other respondents.
Please.
Yes.
Great.
Bill number 41.
Some matter, my lords, appear for the petitioners. This is a matter where land in survey number 18 of Chikkatogur village, my lords, is reserved for being allotted to people belonging to the downtrodden. We are saying that it is also given to us. Now, the other society, my lords, has also filed along with their writ petitions. Total extent is 9 acres, 10 guntas. The overlapping of 1 acre, 6 guntas, my lords. Therefore, my lords, in respect of 1 acre, 6 guntas, if any order is passed by the government, my lords, then it will affect our interest, my lords.
Maintainability of the writ petition.
Yes, I have challenged my lord's order by another writ petition. my lords. I have challenged my lord's order in another writ petition, my lords, in respect of another society and members. There are 2 societies, my lords, respondent number 5 and respondent number 295, my lords. Both the societies have filed a case, my lords, before my lords. Now, one writ petition is disposed of, another writ petition is pending in respect of certain lands in survey number 18 of Chikkatogur village, my lords. Total extent is 9 acres, 10 guntas. If one society is claiming the entire extent, the other society is claiming 1 acre, 6 guntas, my lords. My lords have ordered, my lords, at page 147, in respect of respondent number 6 society, my lords, its case be considered for 9 acres,
At
10.
any rate, I can't consider this petition.
It's because it's my lord's order.
Correct.
It's come before me.
At any rate, it cannot be considered by me.
Plus, our writ petitions are still pending, my lords. And there is a direction by this honorable
Correct,
court.
sir. But what should I do now? Can I consider this writ petition where you are questioning my own order?
It's because it was not brought to my lord's notice, the other writ petition was pending, my lords. We're only saying that, my lords, we be given an opportunity, my lords, both the matters could be clubbed together and heard, my lords.
Having regard to the fact that order passed by me in WP number 10227 of 2020, dated 14th of December 2023, has been called in question and a declaration is sought by the petitioners. In respect of the very same order, the matter has to be considered by any other judge. Full stop.
My lords could do it, my lords. It's actually in the nature of a review, my lords. Yes.
Appropriate orders may be secured at the hands of the Honorable Chief Justice to list this matter before any other bench. ಯಾರು ಇದಾರ ಇಲ್ಲಿ? ಬಿ ಆರ್ ಶ್ರೀವತ್ಸ ನೀವಾ? At the request of learned counsel for petitioner, 2 weeks time is granted to file necessary application for amendment of the memorandum of writ petition. No adjournment. No.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ವಿಡ್ರಾ
ಸರ್ ಪಾಸ್ ಓವರ್ ಇದೆಯಾ ಮಧ್ಯಾಹ್ನಕ್ಕೆ? ಡೈರೆಕ್ಟ್ ಇದೆ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ 2:30
ಇದೆ.
ಫಸ್ಟ್ 2:30 ತಗೋತಾರೆ ಸರ್. ಫಸ್ಟ್ 2:30 ಸೆಷನ್ 2:30 ಲಿಸ್ಟ್ ತಗೊಂಡು ಆಮೇಲೆ
ಇದೆ ಮೇಡಮ್, ಅಷ್ಟೇ ಬೇರೆ ಏನಿಲ್ಲ.
ಬೇರೆ ಏನು. ಆಮೇಲೆ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ. ಥ್ಯಾಂಕ್ ಯು.
42 ಇದೆ ಸರ್. 42 ಇದೆಯಾ?
42 ಇದೆ. 43 ಇಲ್ಲ, ಇದೆ.
ಸರ್ 35 ಏನಾಯ್ತು?
35 46
ಇದು ಸೆಕೆಂಡ್ ಮ್ಯಾಟ್ರಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರ BBMP?
ಯಾವ್ದಕ್ಕೆ?
ಅದು 35 ಅಲ್ಲಿ. ಅದು ಚೈತ್ರಾವತಿ ಅವ್ರದ್ದು ಇತ್ತಲ್ಲ, ಅವ್ರು ಇವಾಗ ಇಲ್ಲ.
ಯಾರೋ ಜೆಂಟ್ಸ್ ಬಂದಿದ್ದಾರೆ.
ಶಾರ್ಟ್ ಐಟ್
ಅವ್ರ ಕಡೆ ಇರ್ಬೋದು. ನಾನು ಅರ್ಥ ಆಗ್ತದೆ, ಒಂದ್ ಫೈಲ್ ಎಲ್ಲ ಮಿಕ್ಸ್ ಆಗೋಗಿದೆ, ಸಿಗ್ಲೇ ಇಲ್ಲ. ನಾನು ಯಾವ್ದೋ ಫೈಲ್ ಕೊಟ್ಟೆ, ಯಾವ್ದೋ ಫೈಲಿಗೆ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು. ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೆ ಹಂಗಾದ್ರೆ ಕೇಳಿದ್ರು. ನಾನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬೇರೆ ಯಾವ್ದು. ಎಲ್ಲಿ ಹುಡ್ಕೋದಪ್ಪ ಅಂತ ತಲೆ ಎಲ್ಲ ಹಾಕಿದಾರಂತಲ್ಲ ಅವರು, ಅವರೇ ಹೇಳಿದ್ದಾರೆ. ಶೀಟ್ ಅಲ್ಲಿ ಇಲ್ಲೇ ಇರೋದಕ್ಕೆ ಕೇಳಿದೆ ನಾನು. 13105 ತಾನೆ? ಪಾಸ್ ಓವರ್ ಇಲ್ಲ, ಅನೌನ್ಸ್ಮೆಂಟ್ ಇದೆ. ಬಂದಿಲ್ಲ, ಬೋರ್ಡ್ ಅವ್ರ ಪ್ರಾಬ್ಲಮ್. ನಾನು ಹಾಕಿದೀನಿ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು, ನಾನು ನೋಡಿದ್ದೀನಿ.
ಅಂದ್ರೆ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಇದ್ದಿದ್ರಿಂದ ಇಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಅಷ್ಟೇ.
ಅದೇ ಅದೇ ಅದಕ್ಕೆ ಅವ್ರ ಕಾಗದದಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅವರು, ಅಲ್ಲಿ ಪುಟಪ್ ಆಗಿಲ್ಲ.
ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದ್ರೆ ನಾವು ಸಿಕ್ಕಿ ತೋರಿಸ್ತೇವೆ.
ಹಾಕಿದೀನಿ, ಪುಟಪ್ ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ ಅವರು. ಬೇಡ ಬಟ್ ಕಾಗದ ಏನ್ ಬಂದಿಲ್ವಲ್ಲ, ಬಿಡಿ ಪರವಾಗಿಲ್ಲ. ಇದು ಮಾಡಿದಾರೆ ಅಷ್ಟೇ, ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಮೆನ್ಷನ್ ಮಾಡಿ. ಅದಕ್ಕೋಸ್ಕರನೇ ಅವರು ಹಾಕಿದ್ರು. ನಾನು ಅದಕ್ಕೆ ಇಲ್ವೇನೋ ಅಂತ ಫೋನ್ ಮಾಡಿದೆ, ನಾನು ನೋಡ್ಲಿಲ್ಲ.
ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ಗೆ ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಹಾಕ್ತಾ ಇದ್ವಾಗ ನಾವು ಎಲ್ಲದಕ್ಕೂ ಕೊಡ್ತಾ ಇದ್ದೀವಿ ಪೋಸ್ಟಿಂಗ್. ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಹಾಕುವಾಗ ಅವ್ರು ನನ್ಗೆ ಯಾಕೆ ಸಿಪಿ ಹಾಕ್ತೀರಾ ಅಂತ ಅದಕ್ಕೋಸ್ಕರ ನಾನ್ ಕಂಪ್ಲೇಂಟ್.
ಬಟ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಿಸ್ ಆಗ್ಬಿಟ್ರೆ?
ಮಿಸ್ ಅಂದ್ರೆ ಅವಾಗ ನಾವು ಪೋಸ್ಟಿಂಗ್ ಕೊಡುವಾಗ ನೋಡ್ಕೊಂಡು ಕೊಡ್ತೀವಿ, ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗುವಂತ. ಪಾಸ್ ಆದ್ಮೇಲೆ
ಬಂದಿದೆ CS, ಅದೇ ಹೇಳಿದ್ನಲ್ಲ, ನಂಬರ್ ಬರ್ದಿರ್ಲಿಲ್ಲ ನೋಡಿ, ಆಮೇಲೆ ಬಂದ್ರೆ ನೋಡಿ. ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ರು ಅಮ್ಮ, ಅದು ಇದಾಗಿರ್ಲಿಲ್ಲ, ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ. ಮೋಸ್ಟ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿರಲ್ಲ. ಯಾವ್ದೋ FR ನಂಬರ್ ಕೊಟ್ಟಿದ್ರು ನಿನ್ನೆ.
ಅಬ್ಜೆಕ್ಷನ್ ಕೂಡ ವೆಬ್ ಪೋಸ್ಟ್ ಆಗಿದೆ ಎಂದು ಚೆಕ್ ಮಾಡ್ತೀನಿ, ನಾನು ಬರ್ದಿದ್ದೀನಿ.
ಅದು ಆಕ್ಚುಲಿ ನಿನ್ನೆ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು
ಬರೆದು ಬಿಡ್ತೀನಿ ಇವಾಗ.
ಇಲ್ಲ, ನಾನು ಡೇಟ್ ಹಾಕ್ತೀನಿ. CS ಮತ್ತೆ IML ಕೊಟ್ಟಿದ್ದು ಅಲ್ಲ,
CS ಎಲ್ಲೋ ಒಂದು ಇದು ಇವತ್ತಿಂದ ಯಾವ್ದಿಲ್ಲ, ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರ
ಅಲ್ಲ. ಈಗ ಬರಕ್ ಕೊಟ್ಟು ನಾನು IML ಹತ್ರನೇ ಕೊಟ್ಟೆ, ಪೋಸ್ಟ್ ಮಾಡ್ತೀನಿ.
ಪೆಂಡಿಂಗ್ ಈಗ ಆರ್ಡರ್ ಆಗಿದೆಯಾ ನಮ್ಗೆ?
ಈಗ ನೋಟಿಸ್ ಆಯ್ತು, ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಅವರಿಗೆ
ಪೆಂಡಿಂಗ್
ಹೋಗುತ್ತೆ.
ನಾನು ಇಲ್ಲಿ ಬರ್ದಿಲ್ಲ
ಏನು ಬರಿ BBMP ನೋಟಿಸ್ ಆಗಿದೆ, MD ರಘುನಾಥ್ KVH ಬಂದಿದ್ದಾರೆ ಅಂತ ಆಗಿದೆ. ನೋಟಿಸ್ ಆಗಿಲ್ಲ,
ಕಾಪಿ ಸರ್ವ್ ಆಗಿಲ್ಲ. KVH
ಸರ್ವ್ ಮಾಡಿದಾರೆ, ಅದಕ್ಕೆ ಬಂದಿದ್ದೀನಿ ಅಂದ್ರೆ ಅವರು.
ನನ್ಗೆ ಅಸೈನ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ,
ನಾನು ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೆ ನಾನು ಬಂದೆ. ಹೋಗಿದೆ ಮತ್ತೆ ಡೇಟ್. ಅದೇನೋ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟೆ, ಪೋಸ್ಟ್ ಆಗಿದೆಯಲ್ಲ ನೋಡ್ಕೊಂಡು.
simply say the competent authority.
Very good.
Although the matter is coming up for hearing on interlocutory application. With the consent of the learned counsels on both the sides, the matter is taken up for final disposal. We'll stop. Next paragraph. The petitioner who
I may be excused for a few minutes.
is said to have acquired right, title and interest ಎಲ್ಲಿದ್ದಾರೆ gift deed?
Next year, page 26.
Under a registered gift deed dated 9/12/2016. Is aggrieved of the impugned order at Annexure Y dated 12/10/2022 passed by the Joint Commissioner, Madhepura Zone, BPMP, Bengaluru, in the matter of transfer of Kata. Full stop. Next paragraph. Learned senior counsel Shri Jaikumar S. Patil, appearing on behalf of the petitioner, submits that the petitioner's brother Shri Ravi Puravankara entered into agreements of sale dated 3/11/1994 and 29/10/1994 with the original landowners respondents number 3 to 9 hearing. For purchasing 5 acres of land in survey number 26/1 to 26/9. All situated at
Junnasandra village.
Junnasandra village, Vartur Hobli, Bangalore East Taluk. Full stop. Learned senior counsel submits that the entire 5 acres of land were converted from agricultural to non-agricultural purposes by way of 9 different orders passed by the competent authority during the year 1995-96, the details of which are also given in paragraph number 6 in the writ petition. Full stop. When the original landowners did not come forward to execute sale deeds in favor of Sri Ravi Puravankara, the said Sri Ravi Puravankara filed original suits in OS number 862 of 1996, 921 of 1996, 1003 of 96, 1004 of 96, 1005 of 96, 1006 of 96, and 1007 of 96 before the first additional civil judge, bracket really senior division, Bangalore rural district, seeking specific performance of the contract. Full stop. The suit was decreed by way of a judgment dated 10/6/2006. Full stop. Thereafter, execution case was filed by Sri Ravi Puravankara, and consequently, the court executed a sale deed in favor of Sri Ravi Puravankara on 14th of August 2009.
7 sale deeds.
Huh?
7 sale deeds.
Full stop. In all, 7 sale deeds were executed in favor of Sri Ravi Puravankara. Full stop. Thereafter, Sri Ravi Puravankara executed a registered gift deed dated 9/12/2016 in favor of the petitioner, who is none other than the sister of Sri Ravi Puravankara, conveying the entire extent of 5 acres to the petitioner. Full stop. Consequent to the execution of the gift deed in favor of the petitioner approached the competent authority of the Brihat Bengaluru Mahanagar Palike for registration of Kata in her name in respect of the scheduled property in terms of the gift deed. Full stop. When the competent authority did not pass any order, and when the petitioner insisted that her case for registration of Kata should be considered, the matter was taken up as an appeal at the hands of the Joint Commissioner, Madhepura Zone, BBMP. Full stop. The Joint Commissioner has passed the impugned order rejecting the claim of the petitioner on various grounds. Full stop. Next para. Learned Senior Counsel Shri Jaikumar S. Patil submits that a plain reading of the impugned order clearly shows that the Joint Commissioner has exceeded his jurisdiction. Full stop. The Joint Commissioner has sought to sit over the judgment and decree passed by the civil court. Full stop. The Joint Commissioner is of the opinion that although the court executed sale deeds in favor of Sri Ravi Puravankara in the year 2009, nevertheless, he did not take actual possession of the suit schedule properties. Full stop. On the other hand, Sri Ravi Puravankara executed a gift deed in favor of the petitioner only in the year 2016, and therefore the delay for seeking transfer of Kata was not explained. Full stop. Learned Senior Counsel submits that in terms of the relevant provision, namely section 114 of the then Karnataka Municipal Corporations Act, 1976, as and when the title is transferred from the previous Katedar, it would be the bounden duty of the commissioner to transfer the Kata in terms of the registered instruments. Full stop. Learned Senior Counsel further draws the attention of this court to the impugned order and submits that the Joint Commissioner has gone to the extent of considering the objections raised at the ends of the contesting respondents herein, more particularly the impleading applicant, Sri K.V. Kupparaju, and has held that it is a well-established principle of law that no gift deed is valid, unless the donor delivers the actual possession of property mentioned in the gift deed to the donee. Full stop. The Learned Senior Counsel therefore submits that it is clear from the plain reading of the impugned order that the Joint Commissioner has exceeded his jurisdiction in considering the validity of the judgment and decree passed by the civil court and the validity of the gift deed executed in favor of the petitioner. Full stop. In that view of the matter, the Learned Senior Counsel submits that the impugned order cannot be sustained. Full stop. Next para. For contra, Learned Counsel for the impleading applicant, Sri K.V. Kupparaju, seeks to submit that although the Joint Commissioner has rightly recorded the objections raised at the ends of the impleading applicant herein, and rejected the application filed by the petitioner, nevertheless, the impleading application filed by Sri K.V. Kupparaju was also dismissed by the Joint Commissioner.
Yeah, dismiss ಆಗಿಲ್ಲ. At the instance of students, but I have not sought for it, but I objected for it, saying that there are appeals pending against the judgment decree path.
ಅದೆಲ್ಲ ಆಯ್ತು.
No orders.
In spite of all this.
I have not sought for any transfer of the
ಅಲ್ಲ
Kata.
sir, whether your application was allowed,
No orders were passed.
I have objected for the application filed by them. For
no,
purpose
no,
of
no
Kata.
formal orders have been passed.
No.
ಏನ್ ಹೇಳಿದೆ? Nevertheless, the Joint Commissioner has not formally allowed or dismissed the application. Full stop. Moreover, it is pointed out from the impugned order itself that the original owners executed a general power of attorney in favor of Shri K.V. Kupparaju authorizing him to apply for conversion of the lands, to form a residential layout and to sell the sites formed in the layout. Full stop. Accordingly, Shri K.V. Kupparaju applied for conversion, obtained conversion orders, and thereafter he formed a residential layout with the approval from the Dodda Kannahalli Gram Panchayat, and thereafter disposed of several sites, and the purchasers of the sites have put up construction on their respective sites, and the Kata have been registered in their names in the office of the BBMP, in the records of the BBMP. Full stop. In support of such contention, the Joint Commissioner has recorded that 26 documents were submitted before the Joint Commissioner on 4/4/2022 to substantiate such contention on behalf of Shri K.V. Kupparaju. Full stop. The Learned Counsel would therefore submit that since the Katas are standing in the name of the individual site owners, this court should not permit the transfer of Kata in favor of the petitioner, unless an opportunity of hearing is given to all such individual site owners in whose favor the Kata have been registered in the records of the BBMP. Full stop. Next para. The Learned Counsel appearing for the respondent BBMP submits that although some of the comments made by the Joint Commissioner touching upon the validity of the judgment and decree passed by the civil court and the validity of the gift deed may be beyond the powers of the joint commissioner, comma, nevertheless, the joint commissioner was required to consider the case of the petitioner having regard to the admitted facts that some of the site owners have got residential houses constructed and the Katas have been registered in their names.
RFAs are also pending.
Full stop. Moreover, the original judgment and decree passed by the civil court is under challenge
Page number 3.
in before this court in RFS
341 page ಅಲ್ಲಿ last line ಅಲ್ಲಿ ಇದೆ.
2145.
341 ಅಲ್ಲಿ last ಅಲ್ಲಿ RFA number
2145.
2145 of 2006, 2146 of 2006, 2147, 2149 and 2150 of 2006. Full stop. Next para. Third, the learned senior counsel on behalf of the petitioner, comma, learned counsel for the impleading applicant, comma, learned counsel ನೀವು ಒಬ್ಬರಿಗೆ ಮಾತ್ರ ಹಾಕಿರೋದಂದ್ರೆ
3 respond number 3 4 respond
all learned counsel Shri B.R. Srivatsa for respondents number 3 to 9 and learned counsel Shri
K.K. Vasan.
ಅಲ್ಲ ಇವರು
Mallikarjun Reddy.
Mallikarjun Reddy
For BBMP.
for the respondent BBMP. ನೀವು ಯಾರಿಗೆ
Impleading applicant. I have filed an application.
ಹೇಳಿದ್ನಲ್ಲ I have said KK Vasant ತಾಕೊಡಿ for impleading applicant.
The application may be allowed because I will be party to the proceeding.
Huh?
I will be party to the proceeding before the joint commissioner. My application may be allowed.
And perused the petition papers. Full stop. Next para. In the considered opinion of this court, the impugned order cannot be sustained for the following reasons. 1. It is beyond the powers of the commissioner to consider the validity of the registered gift deed and to have passed comments on the judgment and decree and the sale deed executed by the civil court. Full stop. The commissioner cannot consider the validity of the gift deed to say whether the gift deed is valid or that the gift deed is invalid, since actual possession of the property was not handed over to the petitioner. Full stop. On the other hand, it was for the contesting respondents, including the impleading applicant, Sri K.V. Kupparaju, to have obtained any order in their favor at the hands of this court in the pending regular first appeals. Full stop. No effort is made by the contesting respondents or the impleading applicant to secure any such interim orders or directions at the hands of this court in the pending regular first appeal. Full stop. 2. The commissioner could not have considered the objections raised at the hands of Sri K.V. Kupparaju since the judgment and decree was passed by the competent civil court in the year 2006, and only thereafter the erstwhile owners are said to have executed general powers of attorney in favor of Sri K.V. Kupparaju.
Not after judgment, my lord. Not after judgment, before judgment.
2008, sir.
2000, the GPA is that 1995.
Huh?
1995 is the GPA.
How could they execute? In
They have
2000,
executed registered
the
GPA.
suit was pending from 1994,
No, no, no,
95.
suit was pending in 1996. Much earlier to filing of the suit. Filed this suit on the agreement of 1994, wherein they settled the claim of the Proankara with two other partners, and they registered the power of attorney in their favor by receiving the full consideration. That's what the case I have made out in the appeal court. ಪೂರ್ವಂಕರ
ಅದು ನೀವು ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ಹೇಳ್ಕೊಳ್ಳಿ, you will see.
ಅದು ಏನಾಗುತ್ತೆ ಅನ್ಕೊಳ್ಳಿ, ನಾಳೆ it will not come in the way of me to argue the matter so far as appeal RFS are concerned.
We are only concerned with your claim and objections regarding the registration of Kata.
Yes, registration of Kata, much earlier to filing of the suit.
We will consider.
Much earlier of the suit.
At any rate, the commissioner could not have sat over the judgment passed by the civil court. Full stop. It is beyond the powers of the commissioner to make any comments regarding the handing over of possession by the civil court in terms of the sale deed executed by the court in favor of Sri Ravi Puravankara. Full stop. Next para. Nevertheless, one aspect of the matter may require reconsideration at the hands of the commissioner, having regard to the findings given by the commissioner, joint commissioner, in the impugned order, namely that Katas have been registered in favor of the individual site owners, and many of them have put up constructions over the residential sites which have been purchased by them. Full stop. Here again, the commissioner cannot go into the validity of the sale deeds got executed by the individual site owners. Full stop. However, what may require to be considered is that the katas have been registered in the name of such individual site owners, and therefore they were necessarily to be heard before any orders could be passed, since it would affect their rights not only in maintaining the kata in the records of the BBMP, but also in respect of the possession of the sites. Full stop. Here again, necessary orders will have to be obtained by the erstwhile owners who are the appellants before this court in the pending regular first appeals.
No, they are not the appellants. They
Neevena?
are not the appellants, they are the respondents.
Neevena?
One Narsamma, the subsequent agreement, registered agreement holder who settled the claim, he is the appellant before the court. Wherein KV Kupparaj,
Agreement holder who objected the decree. She has
And
filed
KV
the appeal saying
Kupparaj-
that my agreement should be considered instead of Purvankara's agreement.
oh no, that's not the one, there are several grounds I have raised. With regard to the power of attorney given by Purvankara to give evidence and so many other things. There are technical points.
Kupparaju is the son of
Only Narasamma, mother of Kupparaju, has filed the appeal stating that so far as agreement are concerned is settled, amount is returned, and the owners have executed the sale deed, and other two partners of Purvankara have assigned the agreement in our favor, has decreased in nullity in the AF.
May have to be obtained by the appellants before this court in the pending regular first appeals, or by any other person who would be affected if the kata is transferred in favor of the petitioner, including the impleading applicant and the individual site owners in whose favor the katas are said to have been registered in the records of the BBMP. Full stop.
Including the respondent here in contesting.
They have not filed any appeal.
No, we are not filed appeal, but we are the
State
parties in
finality
the
So far as erstwhile owners are concerned.
kata stands in our name also, some of the property.
Next para. In that view of the matter, this court has considered opinion that the matter has to be reconsidered by the competent authority, having regard to the amendments brought to the statute and the act itself is now the statute itself is now called the Brihat Bengaluru Mahanagara Palike Act, 2020. While earlier the statute governing the laws of the municipal corporation was known as the Karnataka Municipal Corporations Act, 1976. Full stop. Next para. Consequently, the writ petition is allowed in part. The impugned order at annexure Y dated so and so, passed by the Joint Commissioner, Madhepura Zone, BBMP, Bengaluru, is hereby quashed and set aside. Full stop. The matter stands remitted back to the competent authority who is required to consider an appeal for registration of Kata under the provisions of the BBMP Act, 2020. Full stop. Needless to observe that notices will have to be issued to all the khatedars
Situated in this said survey.
whose names have been recorded in the records of the BBMP
The said survey numbers.
in the
In respect sites, subject matter of
In respect
survey
of the
numbers.
petition schedule property, I will have to put the schedule to the petition.
in the petition schedule property. The full stop, the claim of the impleading applicant can also be heard by the competent authority before considering the claim of the petitioner for registration of Kata in her name. Full stop. Ordered accordingly.
Or the application may be allowed because the requisition may be amended. Thereby can be a
So
part.
your purpose is served. Now I've again said that even before the commissioner, you can be heard. I've said.
And notice ಕೊಡಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ನಾನು ನೋಟಿಸ್ ಹಾಕೊಂಡು ಹೋಗ್ಬೇಕು. They will not issue notice to me. ಅದಕ್ಕೋಸ್ಕರ ಇಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬಿಟ್ರೆ ನೋಟಿಸ್.
My lord, commissioner ಅನ್ನೋ ಕಡೆ ಎಲ್ಲ it may be mentioned as joint commissioner, my lord.
No, the provision says commissioner. So
Delegated
that is why I've used the word commissioner.
Please.
Yes.
My lord, another submission, my lord. My lord, your lordships was pleased to record that my submission is that the order is not sustainable on certain points.
Allah.
That.
Gifted.
Allah. Even on only those aspects of the matter where the commissioner has sought to consider the validity
Please.
of the judgment and decree and the gift deed may not be sustainable, but nevertheless, there are other aspects of the matter which may require consideration.
Allah, none submission that it is not sustainable ಅನ್ನೋದು that may be deleted.
ಆಯ್ತು, change ಮಾಡು.
ಆಯ್ತು.
Yes.
Oblige.
The time frame.
Huh?
The time frame.
ತುಂಬಾ ಜನ ಇದ್ದಾರೆ sometime.
No, having regard to the enormity of the case, we can't fix a time frame. Otherwise, in the meanwhile, you will have to file the necessary application in the RFS. Obtain some orders. Otherwise,
hearing ಬರ್ತಾ ಇದ್ದಾವೆ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ. For last 1.5 years.
Application for interim directions.
Final hearing ಬಂದ್ಬಿಟ್ಟಿದೆ.
That will make the case of the commissioner little bit easier.
ಆಗ್ಬೋದು. I will make.
If there is any order of or direction given not to change the Kata, then they will have to await the final outcome of the appeals.
ಹೌದೌದು. ಆಗ್ಬೋದು.
At least to that extent, you will get some relief. Yes.
Oblige.
Serial number 43, order pass. Serial number 44, Ravi Kumar KN.
Here for the petitions in this matter. Matter pertains to Mysore Urban Development Authority in respect of a single layout plan submitted by the petitioner. The MUDA, they receive the application fee, transfer the whatever processing fee, suddenly come out with an endorsement stating that unless the portion of the 27 guntas of land is relinquished free of cost, the plan sanction cannot be processed with. This matter is covered by 7 judgments of this honorable court, even though my learned friend takes a stand that it is distinguishable. Therefore, I am forced to go into the facts of the case to convince this honorable court that the stand of the MUDA in their objections is to the effect that the 2 judgments which have been cited, which forms part of the records along with the memorandum of writ petition. Today, for the sake of readiness, I am filing a compilation which has all the judgments, which show that the property right of the landowner cannot be scuttled. I am just passing on a copy of the case laws just for my lord's ready reference. It is already there in bits and pieces. Or you can copy. Lord, the principal question which arose for consideration in every judgment which I have cited is whether as a measure of precondition for plan sanction, the local authority local authority or development authority can insist for surrender of land within inverted commas free of cost. So all those, in all the judgments, it has been.
Vivekanand, what is your contention?
No, let's see. These are the judgment which were passed in respect of Bangalore city.
Yes.
Where there is no prescription in the zonal regulation with regard to this relinquishment of the area. The BBMP used to insist the developers or the owners of the property to relinquish based on a circular.
Yes.
This honorable court has held only based on a circular, you can't insist the people to relinquish the area.
Yes.
Now, insofar as Mysore is concerned, there are regulations, development control regulation, which prescribes handing over of these areas free of cost.
So,
I have produced along with my statement of objections.
Yes.
And annexure R6, page 24. And one of the judgment which learned senior counsel has cited, that this is in appeal, appeal has been admitted by the honorable division bench, and the matter is pending. But insofar as the zonal regulations are annexure R6, page 24 minutes. Page 25 is with regard to the development control regulations applicable to all zones. That's class 7. It says where proposals of road widening and building lines are specified, the setbacks and building lines are with respect to the proposed width of the road or depth of the site, whichever is high. Where proposals of road widening of existing roads are not made, the building lines suggested are from the edge of the existing road. The proposals of road widening and building lines are as per table 5.5. Kindly come to page 26, which is the list of important roads, widths and building lines are stipulated. Let's see, insofar as the prescription of the building line and handing over of the land free of cost is concerned, page 37, note 5. Note 5, building lines. Building lines are the imaginary lines on either side of the existing roads, parallel to the center line of the road, up to which any new proposals of building can be built on plots adjacent to the roads. In the case of roads proposed for widening, till they are widened, any proposals of development in the plot by the owner shall reserve portion of their plot required for road widening, and the same shall be handed over to the authority free of cost. The FAR allowed is for the original plot, whereas the plot coverage is for the reconstituted plot, and also in addition provides the minimum setback area required beyond the proposed road edge. This is the provision under which the developer or the owner of the property who wishes to develop the property will have to relinquish the area required for road widening. This honorable court, your lordships, in respect of another matter which was argued before your lordship, by an interim order, where we have pointed out before this honorable court that insofar as 45 meters are roads are concerned, we are seeking for dispensation of 9-meter service road, for which the proposal has been forwarded to the government. The lordships have considered that submission annexure R8, page 44. Taking note of the proposal sent by MUDA to the government for amendment of the zonal regulation, your lordships have directed the government to take note of the proposal and pass an order on the recommendation of MUDA for waiver of the requirement of service road of 9 meters on either side of 45 meters road, except ring road and peripheral road. In respect of all other roads, the prescription of 9-meter service road is not necessary. This matter was heard before the summer holidays. The government has submitted before this honorable court that taking note of the proposals for amendment of zonal regulation, they have notified the draft of the amendment and which has to be placed before the concerned minister because of the code of conduct, they could not process it. This is the status of the amendment to the zonal regulation. If the amendment is approved, then the requirement of 9-meter service road may not arise in the present case. As regards the other portion of the area is concerned, the zonal regulation prescribes that it has to be handed over free of cost. And this zonal regulation is not challenged. Not only the endorsement issued by MUDA, asking the petitioner to relinquish the area required for road widening from 15 meters to 45 meters alone is challenged. Therefore, my submission is all these judgments which are based on decided in respect of Bangalore city, where there are no prescribed regulations in the master plan, cannot be made applicable to the facts of the present case. That is what I have stated in my statement of objection.
Here also they had pointed out to a similar such provision in the master plan, RMP.
Please.
It's a perimeteria, it's a perimeter.
No, it's
Similar provision
It's
in
perimeter.
the RMP.
No, that is.
And this court held, no, you say, just because it is mentioned in the RMP that it has to be handed over free of cost,
Yes,
it totally violates the provisions of Article 300A.
It's the right to develop.
You can't expect a owner of the property to simply give up a portion of the property free of cost. Why should he do it?
Because he is getting the benefit of developmental
You
rights.
can only restrict the building lines, saying, look here, you cannot put up any construction beyond the building lines. That is for the purpose of maintaining a distance between the road and the building.
Please.
It doesn't mean that you have a right to say relinquish a portion of the property free of cost. Just because you write some such word is used there, it will be totally in contravention of Article 300A.
That's the zonal regulations which are referred to in the other judgments are in relation to different context. That is regulation 7.1 of Master Plan 2015. There, these kind of prescriptions are not there. Kindly.
I'm sure the same time.
I have examined it, my lord. They are in perimeteria,
Same.
and my learned friend did put me on extra homework. Serial number 2, MUDA judgment is there. At serial number 2, which we have given a copy.
Is what I have said, against which an appeal is filed and the writ
No,
appeal is
at the
admitted for consideration by the Honorable Division Bench.
In my respectful submission, I am not even claiming any construction right over this property. I have gone on affidavit stating that please allow me to enjoy rest of the 27 guntas of the property. I'm not going to put up any construction. There is a map which has been filed along with the writ petition. May I draw my lord's attention to that map? Kindly see page number 28. I am not even saying that I will put up construction. In fact, I am ready to forego that, right? Subject to valid acquisition, which will come up in future as and when the state government of the MUDA gets wiser and wiser. At page number 28. My case before this honorable court is that I will leave it as a buffer zone. I won't put up any construction. Please allow me to enjoy the property, balance that to 27 guntas. I am just being straight up, plain and simple. They say that till ಮುಫತ್ತಾಗಿ ನೀವು ಈ ಪ್ರದೇಶವನ್ನು ನಮಗೆ ಕೊಡುವವರೆಗೂ ನಿಮಗೆ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಕೊಡುವುದಿಲ್ಲ. That is their case, which my learned friend has to meet with reference to the provisions of law. And the provisions of law, with my respectful submission, they are in perimeteria, absolutely perimeteria. RMP also says shall be reserved. And another aspect is this plot is a single layout development. I am not kindly appreciate to what extent.
Please come to page number 28.
Yes, madam. Yes, madam.
Your submission is.
Yes, madam.
That portion of the road.
Which they are proposing to get it relinquished.
Which may be required.
Yes, madam.
Even leaving out that much.
Yes, madam. I won't put up. My plan will not say that. Nor my.
Where is your proposed plan?
Well, I have filed the proposed plan. I have filed the construct. This is the proposed plan after post inspection. At number 28. Because it's a single layout plan. It is not bifurcating. I am not bifurcating the sites. In fact, my lord will see the legend. Proposed residential single layout plan at the right corner bottom. So number 18/4, Vasaundi village, Kasbauli, Mysore Taluk, Mysore district. Area, road area to be relinquished is their case. My case is that I will reserve that place.
ಅದನ್ನ ಬಿಟ್ಟು what is your proposal? What do you want to do there?
I put up a single commercial
ಎಲ್ಲಿದೆ?
building.
Where is the?
Application says so.
No, in your plan you should have submitted.
My lord, it is there, my lord. Maybe it is not filed with precision. It is there, my lord. It is not disputed. In
Now,
fact-
if you are making a proposal
Yes,
that in respect of this portion of the land,
Yes, my lord.
leaving out this portion,
Yes, my lord.
ಈ portion ಅಲ್ಲಿ
Out.
what do you want to do? If there is any concrete proposal, where is it?
My lord, I will show it.
Then we will issue directions.
Yes, my lord. I will show. Kindly bear with me for a minute, my lord. I will show that. I will kindly bear with me for a minute. Page number 27, annexure VF may kindly receive. This is the endorsement. मैं विषय के संबंध से उल्लेख जिलाधिकारी अनुमोदन ನೀಡುವ
ಅಲ್ಲಲ್ಲ, ನಿಮ್ ಪ್ರಪೋಸಲ್ ಏನು ಅಂತ ಕೇಳ್ತಾ ಇರೋದು ನಾನು. What is your proposal?
Single layout development plan.
ಇದರಲ್ಲಿ what is it that you want to do now?
Commercial, other, I have not, see, there are two phases, building plan and development plan. Non-building plan in a code, I hope my learning friend corrects me if at all I am wrong. Building plan ಕೊಡ್ಬೇಕಾದ್ರೆ layout development plan ಆಗ್ಬೇಕು. ಇಷ್ಟೇ ನನ್ನ layout development plan, single layout development plan ಅಂತ ನಾನು ಕೊಡ್ತೇನೆ ಅಷ್ಟೇ. Then once they sanction, I will go for a building plan sanction. Today, what is transpiring in the mind of the honorable court is that I must show to the honorable court what I am going to put
Yes.
up. My respectful sir.
If your proposal is that
Yes, madam.
I am not going to do anything here.
Yes, ma'am.
I'll keep it reserved.
Yes, ma'am.
I'll put up construction only in this part of the area
I will file.
as permissible in terms of the building bylaws
Yes.
of the Mysore City Corporation.
Doubtedly, I can file an affidavit in that. regard.
ಅದನ್ನ ಕೊಟ್ರೆ
Yes,
we will record it and we will leave it at this.
Yes,
We will direct them to sanction the plan.
Yes, my lord, there is no contradiction.
We will keep the question as to whether you are required to hand over the remaining area free of cost or should they pay you.
My lord will decide that aspect also, my lord, except with, unless through a valid acquisition, if they are entitled to widen, what necessary corollary is that?
We will leave that question open. Since he is saying their appeal has been filed and the matter is pending consideration before the division bench.
Yes, my lord.
In order to enable you to proceed.
Yes, ma'am.
In respect of the remaining portion of the area where they also will have no objection.
Yes, ma'am.
We will issue necessary directions.
Obliged, ma'am. That
As
will
simple
serve
as
the
that.
purpose,
Yes.
that will, could it be called on Thursday, my lord? My learned friend, if at all he has got the papers, he can assist the honorable court on that
Correct.
aspect.
On fact, so your submission is correct.
I'm grateful.
Madam.
So, Thursday, there's a special bench matter on Thursday.
Illa, you tell me whenever you want, we'll have the matter.
Friday.
We'll have the matter listed.
Subject to my lord's convenience on Friday, my lord.
Friday would be half day.
Friday,
but
half day ಆಗುತ್ತೆ.
Tuesday will also, Tuesday if it is.
Next Tuesday, Wednesday, Thursday, whichever you want.
Illa, but I leave it to my lord. I shouldn't be, I leave it to my lord's
Illa,
convenience.
you may choose the date. There is no difficulty. Third, fourth, fifth.
No, earliest next week. Earliest next week, my lord. I'll ask. Would it be on 3rd June, man? Obliged. Interim order is there. There is a technically, there is an interim order.
Fourth August.
Which may-
ಏನಂತ?
The endorsement is stayed.
ಅದರಲ್ಲಿ ಏನು effect, it is not an effective.
No, I am only hesitant since it is.
That is why I am looking at the practical aspect of it.
Yes,
And I want to give relief
yes, my lord. I am
so that you
obliged.
can proceed.
Yes, ma'am.
In respect of the issue as to whether it has to be handed over free of cost or you are entitled for compensation, it will be decided. We will decide it.
Fourth ಆಗ್ಬೋದು. Third ಬದಲು fourth ಆದ್ರೆ.
Fourth ಆಗ್ಬೋದು.
Or could it be day after tomorrow, my lords? I will arrange my work. Could it be day after, my lord? It's okay, it's okay.
30th.
Yes, ma'am. Half a day, it is half a day, we will get the papers.
30th is Thursday.
30th is Thursday. Oh, it's 31st is half a day. 30th subject to my lord's convenience.
ಆಗ್ಬೋದು.
I am obliged, ma'am. In the same stage at the hearing on IA. That we have filed an IA for final dismissal.
In fact, in one of the at the request of the learned senior counsel appearing for the petitioner, release this matter on 30th of May. Yes.
I'm great to apply.
Number 45, Sanjay Reddy AC.
May I please go? Appear for the petitioner's counsel. Now, this is a case where the first respondent, who is a property developer, entered into an agreement with the petitioner society to develop a layout.
First respondent.
As a first contesting respondent. Arunachala. So he entered
R3 and 4.
R3. So entered into an agreement to develop a layout. There are several transactions between us. One of the property which we wanted him to develop, he purchased a piece of that property.
From you?
From us. But has defrauded us, taking undue advantage of the complicity he had with the then office bearers, did not pay the consideration. So it is in respect of that land. There are several other claims between us. According to us, over 17 crores are due from him towards the petitioners. Now, so far as this property is concerned, he did not pay the consideration. So we filed a dispute against him, and that has been decreed. That is settled not by the Karnataka Appellate Tribunal. On the ground, he was not given enough opportunity. I'll satisfy the court that enough opportunity was given. He was given 10 opportunities, but he did not avail them. And ultimately, the claim is resulted in an award being passed. So that has been set at naught, and that is set to stay. So they have made an application for vacating it. We have filed our rejoinder.
This writ petition was filed 12 months after the order was passed for remand. In this 12 months, they participated in the proceedings before the original authority. They have examined witnesses. We have cross-examined witnesses. They have made applications. After undertaking everything, they came before this Honorable Court in 2024. This is an order of October 2022, which is under challenge. I have disclosed, minutes, what all the proceedings which has taken place before the authority to whom the matter is already remanded. They have already participated in the proceedings. After remand, evidence is recorded, and they filed an application.
Let them consider and pass orders.
You participated in the proceedings.
May just take your lordships to the statement of objections.
In that case, matter itself may be heard next week.
Allah.
I'll verify that.
If that is so,
I'll verify that.
If after remand the matter is reheard.
After remand, if they have subjected themselves to the jurisdiction, I'll inquire. Next week, Final hearing
Not yet.
Final hearing because if you have participated in the proceedings after remand,
I agree. I'll verify.
The authority will pass one more order.
I'll verify. And
there is one more issue, my lords, as my learned senior friend said. The respondents 3 and 4 are developers. Agreement is entered into for development of a particular property. Then they say that there is a sale deed which is executed pertaining to one piece of property, which is a sale deed which is executed in my favor, not by the society, but by the owners themselves. But these are all the facts. But the question is, whether a Section 70 dispute can be raised against a developer. And these are two companies. This is a primary society. Very dubious manner in which this society is operating. How can they file a dispute under Section 70 pertaining to a joint development agreement or a development agreement? That is the principal question which has to be answered. Because Section 70 specifically says...
I'm ready to address that issue.
Not here.
There they have to address it.
Authority will have to address himself.
That has to be
and,
addressed there.
Take a stand.
Yes.
All right, next week I'll make a submission.
Learned Senior Counsel Shri
cross-examine ಮಾಡಿದ್ದೀರಿ ಅಂತಾರೆ.
D.R. Ravishankar, appearing on behalf of response number 3 and 4, submits that after the impugned order was passed by the Karnataka Appellate Tribunal, remanding the matter back to the
Second respondent.
Additional Registrar of Cooperative Societies, the parties have participated in the proceedings, adduced evidence, and the matter may have to be reheard and final orders may have to be passed by the competent authority. Full stop. It is therefore submitted that at this stage, there may be, this court may not be required to consider the impugned orders passed by the tribunal. Full stop. Moreover, it is the contention of the contesting respondents that the petitioner society could not have invoked the jurisdiction of the registrar under the provisions of the Karnataka Cooperative Societies Act. Insofar as the contesting respondents are concerned, since admittedly the contesting respondents are not part of the society,
Lords,
or
what they
not
do?
members of the
Lords, we are enrolled as nominal members. 3 and 4 are enrolled as nominal members is what is the pleadings. The question is, the section 70 dispute is anything arising under the scheme of the Cooperative Societies Act, they can decide. But this is a development agreement to a developer. Lords, now something
That
like
issue,
this.
if my learned friend is raising, I am prepared to address it.
That's
So
my
let-
contention.
No, no, I'm
Only contention.
Allah,
I'm only recording the submission and I'm adjourning matter.
no, I am contesting that position. If my learned friend is pressing that point. I am
Urge it there.
joining issue on that.
That issue also will be urged there, and the competent authority will decide that question also. But if you have participated in.
I'll verify. Court may leave it at that because ಇನ್ನೇನ್ ಮುಂದಕ್ಕೆ ಏನ್ ಹೇಳಿದ್ರುನು
ಇಲ್ಲ,
the
ಇಲ್ಲ, I'm only
arbitration
recording
will
the
be influenced by that statement.
And I will be recording your submission that you will take instructions and make submission.
Yeah.
Aste.
Allah, this submission about the maintainability is not an issue that arises in this petition. If at all he succeeds in getting the matter remanded, then only that issue arises there, not here. This issue is not decided by the KAT.
Sorry.
So therefore, I request the court to eschew consideration of that issue.
What he is submitting is that this issue will be raised before the competent
ಅಲ್ಲ
authority.
ಅದು ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅನ್ನೋದು ಅದು ಇಟ್ ಇಸ್ ಸ್ಪೆಕ್ಯುಲೇಟಿವ್ ಇಮೇ ಆರ್ ಇಮೇ ನಾಟ್ ರೈಸ್
Which are making.
ಯಾಕೆಂದ್ರೆ ನಮ್ಗೆ 17 ಕೋಟಿ ಬರ್ಬೇಕು ಅಂತ ನಮ್ಮ ಇದು
That is his submission and I have
ಬರೀ
recorded it.
3 ಕೋಟಿನೇ.
I will also record your submission.
Yeah, my submission is that statement is false
All right.
and the dispute is maintainable.
All right. ಏನ್ ಹೇಳ್ದೆ? Since the matter arises out of a joint development agreement between the parties.
Yes, ma'am.
And it would be beyond the scope of the registrar to consider such claim under the provisions of the act. Full stop. Next para. For contra, learned senior counsel, Professor Ravi Varma Kumar, appearing on behalf of the Petitioner Society, submits that insofar as the maintainability of the claim of the society before the registrar is concerned, it is not the issue that was raised before the tribunal, and therefore the same cannot be submitted before this court. Full stop. However, the learned senior counsel fairly submits that he would seek instructions from the petitioner as to whether they have participated in the proceedings after the matter was remanded by the tribunal, and thereafter make submissions before this. Full stop. Release this matter on 4th of June.
Lords,
It Interim order granted earlier stands extended till next date.
Forty-six, section Basuraju.
These writ petitions, I have made an application for impleadment. I have made an application for impleadment.
46.3, we have made an application for it.
Intervenor application.
So
Willard,
we
my
are also
submission is,
contesting for.
instead of hearing applications independently, matter could be heard on merit, allowing them to argue their points also as an intervener. Now, moment they implement and they have to file objection, it would only consume the time and ultimately purpose of the petition would be frustrated. Therefore, let they can argue their point along with us. Either they support me or not to support it, leave it to them. Submission is, my lord, it is a question where a delimitation process of a federal society have taken place when the election process have been commenced and term of the present office bearers is going to be expired. Whether it is permissible or not is a first question without consultation with the election commission, which is constituted under the provisions of the act. Secondly, my lord, this geographical location is one of the yardstick to be taken note of when there would be an alteration warranted for the purpose of delimitation is concerned. Whether that have been followed or not is a question.
So far as my petition
Now,
is concerned,
my learned friend's submission is fair enough that but we have to file our objections. That is because the false statements are made. They are parties to the resolution that has been passed. Therefore, kindly formally allow it. We will not seek any adjournment. Any date convenient to the court, we will address the argument.
Including
We'll file.
application has been pending for months.
Yeah, we filed the application 5 months ago.
for the three matters. Reconstitution of one of the society. Reconstitution of one of the constituencies of the federal society. By means of an amendment to the bylaw, is without incorporating it as a part of the agenda
Yes.
or it was placed before the board.
Correct.
So therefore, in the absence of an agenda, there is no question of accepting any amendment to the bylaw in another. Of course, other contentions are also, I say with another significant. But here, on the threshold, the reconstitution members of one of the constituency where my is involved was never the subject matter of an agenda before the board.
This is 46.3, which Mr. Ravi Shankar is appearing on. Prayer is limited only to the extent of consideration of his representation. That has been considered, the amendment has been approved by the registrar.
Yeah.
He has to file an appeal.
Appeal.
Now he has not even challenged the impugned order, subsequent order passed by the, no, to go into merits of the order of approval by the registrar does not even arise. We have filed our impleading, we have pointed at that. He has not even challenged that order subsequent.
Willard, in our petition, what happened?
That's what we have to be impleaded.
Petitions were presented while the process was pending before.
Anyway, that is addressing on merits.
Merits.
Yeah,
I will complete my. what
my
I-
learned friend is fair enough in saying that the matter has to be heard. We'll file our objections, formally implead us.
Bangalore Cooperative Milk Union.
Yes.
Who is appearing?
I am appearing for that.
Have you filed objections?
We have filed our objections in this matter.
So if you please go through that and all your contentions are also raised there, we will proceed to hear the matter.
That
was the order on the last
merits,
occasion.
if your lordships here, but so that tomorrow it should not appear. If at all, my lords, anybody goes to an appeal that we did not, if your lordships here.
That's, we have already said. We never.
I'll look into it. I'll look it.
All the grounds are raised.
I'll take my.
They are at liberty to address any argument what they want with reference subject matter is concerned.
My
We welcome it also.
Allah, my learned friend's client was present in the meeting. She has agreed. She has participated. And she has approved the amendment. Now she turns around at the instance of somebody.
Willard, I cannot.
Therefore,
response to
now
this
we'll have to
now.
place them by way of affidavit, as for an affidavit. These are facts to be, therefore, it would be advised. Yeah. Formally, we'll file our objection.
Fix any date.
We'll not seek any adjournment. I assure
We
you.
are, we are requesting Millards for an expedited hearing. One after the other person is coming as an impleading applicant or an intervening applicant. We are never opposing their arguments in the matter.
May be listed on third, my lord, because this election process where the some things are things are issued. Now, because of that, elections are postponed and no decision is taken. That calendar, that code of conduct would expire on 6th June.
election
Therefore, matter may kindly be 1 minute.
election, cooperative election.
1 minute, my lord. Notification was issued
Election
postponing
result-
all elections because of parliamentary election. Code of conduct is in the field. Code of conduct expires on 6th of June. Before that matter has to be heard. Otherwise, my lord, they will notify the election. Then petition would not be heard saying that process have been commenced.
Sir, I am ready to address the matter even during this week. I will not seek. All that I am praying is let us be implemented.
Lords may kindly see the previous order sheet.
Give us
This is
2 days.
essentially what is agreed already. 24/4/24. It is made clear that if the present petitions on merits are not decided on 6/6/24 by 6/6/24, when the code of conduct which sees elections can be held, then the court may consider the grant of interim order after hearing the parties.
Yes.
So therefore, it is made clear that the matter has to be heard on or before 6. That's the request which we are making. Otherwise, Millard's interim order has to follow is what this coordinate bench has said.
This matter.
On third, my they may get the time to file the counter because Sunday and Monday, Saturday and Sunday is intervening. As far as the benefit, we are making the request. Let me on Monday.
You are not ready, Rajgopal. You are not ready.
3rd of June 2024 at 2:30 p.m.
Please.
An understanding that the matter will be heard and disposed of finally. Please.
With liberty for us to file our objections.
In the meanwhile, stop. In the meanwhile,
impleading
objections, if any, from the impleading applicants,
please,
to the main petition,
main writ petition
may be filed.
Oblige.
ಆಗುತ್ತೆ ನಾವು ಮಾಡ್ತೀವಿ ಬನ್ನಿ. ಬಟ್ ಮಾತಾಡಿ ಮಾಡಿ.
Serial number 47. Sachin Jainandan.
46 ಆಗಿದೆ, 47.
Serial number 47.
Appearing for the respondent number 1 in this.
ಎಲ್ಲ ಹೇಳಿದೆ.
ಪಾರ್ಟಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಟ್ರೆ
My lord, in the last occasion, we have filed a memo, my lord, and along with it, we have filed an endorsement, my lord. My lord, alternative shops will be allotted to the petitioners, my lord.
Alternative shops
Will be allotted to the petitioners, my lord, due to elections, my lord.
TMC.
Please.
Yav TMC?
My lord.
Belur.
Huh?
Belur.
Belur TMC.
Not to carry on any business in poultry and chicken, your lords. Fish.
Matter is called out. There is no representation for the petitioner. So please release this matter on 4th of June.
Please.
List number 2, serial number 1, Dhananjay Kumar.
ಆಯ್ತಲ್ರಿ ಇದು EP. ಕೊಡಿ.
Appearing for petitioners, my lord.
Ah,
My lord, the petitioners are challenging the auction.
please come this way. Yes,
My lord, the petitioners are challenging the auction notice dated 15/4/2024, which is issued by the respondent society, my lord.
yes.
My lord, the outstanding loan amount is 11,77,641 rupees, my lord. And the auction is supposed to take place today, your lordship.
Ah,
Your Honor, the petitioner has availed the term loan facility from the respondent society for the residential property, Your Honor, which is the suit scheduled property in this matter. Your Honor, the petitioner has been prompt in paying the loan amount since the beginning of the loan, Your Lordship. After the pandemic, that is the COVID-19, the petitioner was not able to pay the loan amount regularly, but she has made several attempts to make the payments on the later dates. But in spite of her attempts, my lord, the respondent society has issued the impunged auction notice dated 15/4/2024, my lord. My lord, after the issuing of this notice, the petitioner has made several requests to the bank, and she has also made several installment thereafter, and also have requested for certain time and to regularize the loan there onwards, your lordship. But the respondent society, having failed to accept these requests made by the petitioner, has made by the petitioner, has issued this auction notice and also directed the payment of the full amount of 11,77,641 rupees, my lord. My lord, having this scheduled property being a residential property, she has made several installments after the issuing of this auction notice, my lord. However, the respondent society has issued this auction notice without giving a demand notice to the petitioner, which is must as required by the law, your lordship. Your lordship, the respondent also did not consider the request made by the petitioner and have not given any opportunity for the petitioner for the regularization of this loan, your lordship. And hence we have challenged this impunged auction notice. If your lordship, this impunged auction notice is impugned auction notice is executed, the petitioner will be dispossessed from her property, residential property, your lordship.
How much are you going to deposit?
15%.
Huh?
We are supposed to deposit 11,77,641, which is an outstanding amount, your lordship.
Yes.
We are ready to deposit 15% of the. Your lordship, kindly consider this matter because she is a single mother and she is alone taking care of this family, and she's not able to make arrangement for the entire lump sum amount, your lordship. And it is a residential property of the petitioner, your lordship, and she is in possession of this property.
You availed the loan for what purpose?
Your lordship, due to certain issues, they wanted loan for the construction purpose, your lordship.
Construction where?
Construction in their in the
Same property?
Yes, your
On the
lordship.
same property?
Yes.
You have put up construction and you are residing there?
Yes, your lordship.
Huh?
Yes.
Have you stated in the petition?
Council seeks ignorance for the oversight.
You will have to deposit 3 lakhs.
Yes, your lordship. We will comply with that.
3 lakhs within 4 weeks.
Your lordship, can it be 6 weeks?
Purple. Learned AGA takes notice for respond number 1. Issue notice to respond number 2. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. We'll stop. Next para. Learned counsel for the petitioner submits that the petitioner obtained financial assistance from the second respondent, Cooperative Society, for putting up a residential building over the mortgaged immovable property. Full stop. Accordingly, the petitioner has put up the construction and is residing in the same premises. Full stop. Learned counsel submits that the petitioner was prompt in repaying the EMIs till the COVID-19 broke out. Full stop. After the calamity, the petitioner could not regularly repay the EMIs. Full stop. Nevertheless, the petitioner has been paying the EMIs with great difficulty. Full stop. The learned counsel would therefore submit that since the petitioner is conceding the fact that she has obtained loan from the second respondent, Cooperative Society, and if reasonable time is granted to the petitioner, she will make arrangements to repay the entire outstanding loan amount along with the accrued interest. And to show the bona fides of the petitioner will pay rupees 3 lakhs, which would be a little more than 25% of the demanded amount. The impugned auction notice may be stayed. Full stop. Next para. Placing on record the submission of the learned counsel for the petitioner, the second respondent, Cooperative Society, is directed not to proceed with the auction in terms of the impugned auction notice at Annexure A till the next date of hearing. Not full stop. Subject to the petitioner depositing rupees 3 lakhs with the second respondent, Cooperative Society, within a period of 4 weeks from today. Full stop. Release this matter.
Not one submission before that.
On 1st of July 2024.
The time schedule was for the auction was 11 o'clock, my lord. If it has happened, the sale confirmation may be stayed. If auction is took place, then
Your lordship,
on lastly. If not already auctioned. ಆಮೇಲೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ
The confirmation
the auction has proceeded
proceeded.
this morning in
Con-
terms of the schedule,
Scheduled.
in terms of the impugned auction notice.
Auction.
Then the second respondent is directed not to confirm the sale in favor of the successful bidder till necessary orders are passed by this court.
Sir, 49 ಏನಾಯ್ತು ನೋಡಿ sir. Final year. 49. Final year.
Next week, sir.
Next week.
Serial number ಏನು? Next week. Date now. Next week. 53 ಎಲ್ಲ ಅಷ್ಟೇ ಸರ್. ರೀಚ್ ಆಗಿಲ್ಲ ಯಾವುದು ಎಲ್ಲ ನೆಕ್ಸ್ಟ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 52
ತಗೋತಾರ ಅದಕ್ಕೆ. 53 ಯಾವಾಗ ಸರ್ ಲಿಸ್ಟ್? ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್. ಡೇಟ್ ಯಾವುದು? ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಮೇಡಮ್.
ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ ಬಿಸ್ನೆಸ್ ಅಲ್ಲಿ ಒಂದು ಅರ್ಜೆಂಟ್
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಬಲ್ಕ್ ಮಾಡಬಹುದು ಬಿಸ್ನೆಸ್ ಅಲ್ಲಿ. ಹಾ ಅವ್ರಿಗೇನ್ ಕೊಡೋದು? ದಾಟಿದ್ರೆ ಇಲ್ಲ ಪೆಂಡಿಂಗ್ ತೋರಿಸುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್
ತೋರಿಸ್ಬೇಕಂತ ಟೆಂಪ್ಲೇಟ್ ಬರುತ್ತೆ, ತೋರಿಸ್ಬೇಕಂತಿಲ್ಲ ಬರುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫ್ ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಓಕೆ ತಗೊಳ್ರಿ ಮೇಡಮ್. ಎತ್ ಮಾಡಿದ್ರಿ ಕಾಲ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಾಟ್ ರೀಚ್ಡ್.
ನಿನ್ನೆ ಫೋನ್ ಮಾಡಿದ್ರೆ 5 ಗಂಟೆಗೆ ಬಂದಿತ್ತು.
ಎಲ್ಲಿಗೆ ಫೋನ್ ಮಾಡಿದ್ರು?
ನಿನ್ನೆ ಫೋನ್ ಮಾಡಿದ್ದೆ.
ಯಾರಿಗೆ ಸರ್?
ದೇವದಾಸ್ ಸರ್
ಸಾಹೇಬ್ರಿಗೆ.
ಚೇಂಬರ್ ನಂಬರ್
ಹೋದ್ರೆ
ನಂಬರ್
ಏನ್ ನಂಬರ್ ಸರ್? ಇದೆ ಕಾರ್ನರ್ ಅಲ್ಲಿ ಇದೆ, ಫಸ್ಟ್ ಕಾರ್ನರ್ ಅಲ್ಲಿ ಇರೋದೇ ಅವ್ರು. ಅಲ್ಲಿ ಹೋಗ್ತಿರಲ್ಲ, ಇಲ್ಲಿ ಕಾರ್ನರ್ ಅಲ್ಲಿ ಇರೋದೇ ಅವ್ರ ಚೇಂಬರ್. ಬೋರ್ಡ್ ಇದೆ ಅಲ್ಲಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ 35 ಇತ್ತು
ಅಲ್ಲ ಅದು